Good morning. Nice to see you. You're often helpful to us get ready for this. Yeah, great. I'll be loud. Peeled all my time back. Get out of here.
So here's the argument.
All right, thank you.
Do you have your press ID? Perfect. Thank you very much.
The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on oversight of the Department of Justice. I'll begin by recognizing myself for an opening statement. Good morning. Today we welcome Attorney General Jeff Sessions for the Judiciary Committee's annual Department of Justice oversight hearing. Mr. Attorney General, you have a long and distinguished career in public service. You've continued that service by leading the Department of Justice, an agency that, by its very nature, is prone to controversy because of the public's varied opinions on what it means to seek and obtain justice. However, you clearly understand that the department you lead must have the confidence of the American people, even when your decisions are not always well received. Your first year leading the Department of Justice has not been without difficulty, which is expected at the outset of a new administration. While much has been done to correct the improper political engagement by the Department of Justice under the Obama administration, more work must be done to ensure the department is operating to impartially administer justice. Our last DOJ oversight hearing was beyond disappointing. Attorney General Loretta Lynch gave the least fulsome and least transparent testimony that I can recall in my time in Congress. It was plainly a disservice to the American people. Ms. Lynch failed to respond substantively to nearly every question posed by members of this committee. Before Ms. Lynch, former Attorney General Eric Holder became the first Attorney General in history to be held in contempt by the House of Representatives for his own stonewalling with regard to documents connected to the reckless Operation Fast and Furious. I expect, Mr. Attorney General, that you will be more willing to candidly answer questions from members on both sides of the aisle. You're going to hear question after question today concerning your knowledge of or involvement with Russia and its alleged efforts to interfere in the 2016 presidential election. Whether it concerns your work on behalf of now President Trump during the campaign or your service in the Senate, I suspect this theme will be a constant refrain from my friends on the other side of the aisle. While I understand your decision to recuse yourself was an effort by you to do the right thing, I believe you, as a person of integrity, would have been impartial and fair in following the facts wherever they led. I have chosen, as chairman of this committee, to let Special Counsel Robert Mueller do his job, free from undue political influence. At the same time, however, this committee will do its duty and conduct oversight of the Department of Justice. To that end, we sent 2 letters to you, one in July and another in September, calling on you to name a second special counsel to restore the public's confidence in our justice system. Numerous matters connected to the 2016 election remain unresolved. To date, the department has not appointed a second special counsel. Consequently, this committee had no choice but to open our own joint investigation with the House Oversight and Government Reform Committee to review DOJ and FBI's handling of the investigation into former Secretary Hillary Clinton and her mishandling of classified information. As we said earlier this year, it is incumbent on this committee in oversight capacity to ensure that the agencies we oversee are above reproach and that the Justice Department in particular remains immune to accusations of politicization. Whoever is Attorney General, the Justice Department must even-handedly administer justice. You have recused yourself from matters stemming from the 2016 election, but there are significant concerns that the partisanship of the FBI and the department has weakened the ability of each to act objectively. I look forward to hearing your thoughts on this and what steps you are taking to remove politics from law enforcement. However, these investigations are but a few of the many important issues we need to discuss today. For instance, we just overwhelmingly reported the USA Liberty Act out of committee last week. This bipartisan legislation would reauthorize Section 702 of the Foreign Intelligence Surveillance Act. The administration has chosen to oppose any reform of the law. I understand the desire for a clean reauthorization of this vital program. However, I believe this stance is a miscalculation that risks further eroding trust in our intelligence apparatus. We hope we can work with you now that the USA Liberty Act, which reauthorizes a law that is vital to our nation's battle against terrorism while protecting American civil liberties, has been reported out of the committee. This is especially important given the ongoing threat of terrorist attacks in the United States. As we all know, not 2 weeks ago, 8 people were killed and almost a dozen injured when an ISIS-inspired jihadist drove a rented pickup truck into a crowded bicycle path near the World Trade Center in New York. The terrorist threat is real and ongoing. We cannot afford to play politics with national security. I also look forward to continuing to work with you on efforts to reform our nation's criminal justice system. There is bipartisan support to do this in Congress, and with your help, we can make changes that crack down on violent offenders while also doing more to rehabilitate federal prisons and curb abuses in the system, as well as excessive punishments. To your credit, since you assumed leadership of the Department of Justice, there has been a significant increase in the prosecution of firearms offenses in the United States. For years, I have criticized lax enforcement of the gun laws already on the books. Enforcing these laws is the most effective way to combat violent crime in our cities and neighborhoods. Under your leadership, the number of defendants charged with unlawful possession of a firearm has increased by nearly 25%. The number of defendants charged with armed drug trafficking has increased 10%. I commend you for your focus on these prosecutions because they will help make our streets safer. There are many other matters on which we share common ground. especially when it comes to rectifying the failures of the Obama administration. For example, earlier this year, the House passed legislation to ban settlement payments to non-victim third parties, following your policy directive to shut down the use of such mandatory donations. These reform initiatives followed a concerted effort by the Obama administration to use settlements to benefit its political allies. We commend your efforts to combat illegal immigration, protect our citizens from criminal aliens, and to fight back against so-called sanctuary cities. More than 2 years have passed since Kate Steinle was murdered by an illegal immigrant who had been deported 5 times. We have addressed this issue head-on by moving legislation to combat sanctuary cities and find and remove criminal gang members. Mr. Attorney General, our country is at a crossroads. Our constituents are gravely concerned that our justice system does not work for them. Under your leadership, the Justice Department has taken strides to mitigate the harms done in the prior administration. I implore you to work with us to continue that trend, and I thank you sincerely for your appearance here today. I now recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman. Top of the morning. In the ordinary course of business, any one of a dozen topics related to the Department of Justice would be worthy of its own hearing. And to be clear, I would rather spend our time today discussing the upkeep of the criminal justice system, the enforcement of civil rights, and the work we must all do to ensure access to the ballot box. Instead, we must spend our time debating the troubles of a wayward administration, how the Attorney General conducts himself before Congress, how President Trump undermines the integrity of the justice system, and how the department continues to ignore the oversight requests of this committee. Although this is the Attorney General's first appearance before the House, he's already made 3 visits to our colleagues in the Senate. At his confirmation hearing, he testified that he did not have communications with the Russians. Last month, he testified that a continuing exchange of information between Trump surrogates and intermediaries for the Russian government did not happen, at least to my knowledge, and not with me. We now know, of course, that neither of these statements is true. Shortly after the Attorney General made the first comment, the Washington Post reported that he met with the Russian ambassador at least twice during the campaign. In the past month, we've also learned that the Attorney General must have been very much aware of a continuing exchange of information between the Trump campaign and the Russian government. In charging documents unsealed last month, George Papadopoulos, a foreign policy advisor to the Trump campaign, admits to extensive communications with Russian contacts. At a March 31st, 2016 meeting of the campaign's National Security Advisory Committee, attended by candidate Trump and chaired by Senator Sessions, Mr. Papadopoulos stated in sum and substance that he had connections that could help arrange a meeting between then candidate Trump and President Putin. It does not matter, and has been reported, that the Attorney General remembers this meeting after the fact. Remembers it so vividly, in fact, that 2 unarmed sources say the senator shut George down. Under oath, knowing in advance that he would be asked about this subject, the Attorney General gave answers that were at best incomplete. I hope the Attorney General can provide some clarification on this problem in his remarks today. I also hope that he can assure us that the department is weathering near daily attacks on its independence by President Trump, and that no office of the department is being used to pressure the president's political enemies. In recent months, President Trump has attacked the beleaguered Attorney General and criticized his very weak position on Hillary Clinton crimes, in quotation. The president has talked openly about firing the leadership of the department, including the Attorney General, the Deputy Attorney General, the former acting director of the FBI, and Special Counsel Robert Mueller. He did fire former FBI Director Comey, in his own words, quote, because of that Russia thing with Trump and Russia, in quotation, as well as acting Attorney General Sally Yates and all 46 sitting United States attorneys. Last year, he denigrated a federal judge because of his, quote, Mexican heritage, unquote. And Judge Curiel was born in Indiana, by the way. Last month, in a radio interview, President Trump said he was very unhappy with the Justice Department. Hours later, he proclaimed the military justice system a complete and total disgrace. But the one that sticks with me is the president's July interview with the New York Times. In that interview, he begins by once again attacking the Attorney General's credibility. Sessions never should have recused himself, the president complains. Then the conversation takes a sinister turn. When Nixon came along, out of courtesy, the FBI started reporting to the Department of Justice. But the FBI person really reports directly to the President of the United States. He goes on. I could have ended the Flynn investigation just by saying they say it can't be obstruction because you can say it's ended, it's over, period. As is often the case, the president requires some correction. The director of the FBI reports directly to the Attorney General and has since the founding of the Bureau, it can be obstruction of justice if the president orders an investigation closed with a corrupt motive. But what strikes me about these comments is the president's view that the criminal justice system serves him and not the public. President Trump seems to believe that on a whim he can bring pressure to bear on his enemies, dismiss charges against his allies, and insulate himself and his family from any consequence. I cannot overemphasize the danger of this perspective poses to our republic. And I've served on this committee long enough to remember another president who shared this view. I was myself on Richard Nixon's enemies list. And although we worked to hold that administration accountable, our work is not complete. We must all remember our common responsibility to prevent that kind of abuse from happening again. I will look to the Attorney General's partnership in this effort, but I've begun to worry about his resolve. Last night, in a letter sent by the department to Chairman Goodlatte, without so much as a copy to the ranking member, by the way, the Assistant Attorney General seems to leave the door open to appointing a new special counsel to cater to the president's political needs. The fact that this letter was sent to the majority without the customary and appropriate notice to me indicates that the charge given to the department officials to evaluate these issues has political motivations. Now, in his own words, the Attorney General is recused from any questions involving investigations that involve Secretary Clinton. Further, we cannot refer an investigation to a second counsel if we lack the evidence to predicate a criminal investigation in the first place. Virtually every Clinton-related matter that President Trump complains about has been well litigated, carefully examined, and completely debunked. Still, to quote former Attorney General Michael Mukasey, putting political opponents in jail for offenses committed in a political setting is something that we don't do here. The threat alone resembles, in his words, a banana republic. Finally, there is the matter of routine oversight between hearings. In the recent history of this committee, new attorneys generally usually come to see us within 2 or 3 months of taking office. No attorney general in recent memory has taken more than 6 months before making an appearance here. Attorney General Sessions has broken that norm. He has had more than 10 months to settle in, making our communications with the department between hearings that much more important. To date, my colleagues and I have sent more than 40 letters to the Trump administration asking for information necessary to carry out our oversight responsibilities. We have sent more than a dozen of these letters directly to the Attorney General. To date, we have not received a single substantive response. We can disagree on matters of policy, Mr. Attorney General, but you cannot keep us in the dark forever. When we make a reasonable oversight request, we expect you to reply in a prompt and responsive manner. And I hope you can explain why your department has chosen to ignore these letters. More importantly, I hope that you will be more forthcoming with your answers, both in your testimony today and in the weeks to come. And I look forward to your testimony. And Mr. Chairman, I thank you and yield back the balance of my time.
Thank you, Mr. Conyers. Without objection, all other members' opening statements will be made a part of the record. We welcome our distinguished witness, and if you would please rise, I'll begin by swearing you in. Please raise your right hand. Do you solemnly swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record show that the witness answered in the affirmative. Mr. Jeff Sessions was sworn in as the 84th Attorney General of the United States on February 9, 2017. From 1996 to his confirmation to lead the Department of Justice, Mr. Sessions served as a United States Senator for Alabama. Previously, Attorney General Sessions served as an Assistant United States Attorney and United States Attorney for the Southern District of Alabama, Alabama Attorney General, and Captain in the United States Army Reserve. Attorney General Sessions is a graduate of Huntingdon College and the University of Alabama Law School. Welcome, Attorney General Sessions. Your entire written statement will be entered into the record, and we ask that you summarize your testimony in 5 minutes. I noted that the ranking member took a few more minutes than that. If you find that necessary, please feel free to do that as well. Welcome.
Thank you very much, Mr. Chairman. It's an honor to be before this distinguished committee, having served 20 years on your counterpart in the Senate, the Senate Judiciary Committee. Mr. Chairman, I must note that I note with regret your announcement of retirement, and I know that our relationship has been good in the past, and I hope it will continue to be good as you serve here. You've done a fabulous job in leading this committee. On my first day as Attorney General, I spoke about, quote, the critical role we at the Department play in maintaining and strengthening the rule of law, which forms the foundation of our liberty, our safety, and our prosperity. In this rule of law, we are blessed beyond all nations. So I truly believe that. And at this department, we must do all we can to ensure that it is preserved and advanced. Such ideals transcend politics. From that day to today, we at the Department of Justice have worked to be faithful to that mission. Let me share some things we've done initially. The President sent us an order to reduce crime, not to allow crime to continue to increase, and we embrace that mission. The violent crime rate has risen, and the homicide rate has risen by more than 20% in just 2 years, really after 30 years of decline in violent crime. After a careful review, we have established a reinvigorated Project Safe Neighborhood program as the foundational policy for public safety. It has been proven to get results. In its first 7 years of implementation, PSN reduced violent crime by 4.1%, with case studies showing reductions in certain areas where it was intensely applied of up to 42%. So we're also focusing on criminals with guns. As you mentioned, Mr. Chairman, we've seen a 23% increase in gun prosecutions in the second quarter of this fiscal year, my first year. And I'm honored to lead the superb men and women of the FBI, the Drug Enforcement Administration, ATF, and the United States Marshal Service, who work together every day with our state and local partners in this core crime-fighting mission that is the responsibility of the department. Last year, we saw a staggering 61% increase in the number of law enforcement officers killed in the line of duty because of a felony. And on average, more than 150 officers were assaulted every single day. These numbers are unacceptable. Fortunately, the President understands this. He's directed us at the beginning of my administration to back our men and women in blue. We are making it clear that we stand with our law enforcement partners 100%. They are the solution to crime, not the problem. We've also protected the rule of law in our own department. We prohibited so-called third-party settlements that were being used to bankroll special interest groups. We've settled civil cases regarding the Affordable Care Act's birth control mandate, settled the cases of many groups of tax-exempt groups whose status was significantly and wrongfully delayed by the Internal Revenue Service. We've also provided legal counsel to this administration in favor of ending several other unlawful policies. This includes President Trump's order ending billions in funding for insurance companies that were not appropriated by Congress under the Affordable Care Act. This action, which the House had filed a lawsuit to stop, put an end to one of the most dramatic erosions of the congressional appropriations power in our history. House members, you are correct to challenge that. You won in the district court. We believed you were correct, and we had that. We reversed the policy and had that matter withdrawn, the policy withdrawn. We put an end to actions by the previous administration to circumvent Congress's duly passed immigration laws on the DACA. The policy gave individuals that were here illegally certificates of lawful status, work permits, and the right to participate in Social Security. We withdrew that unlawful policy, and now the issue is in the hands of Congress, really where it belongs. We have filed briefs defending properly enacted state voter identification laws, lawful redistricting plans, religious liberty, and free speech on college campuses. In short, it is our mission to restore the American people's confidence in the Department of Justice by defending the rule of law and enforcing the laws as you have passed them. And it is a mission we are honored to undertake. In response to letters from this committee and others, I've directed senior federal prosecutors to make recommendations as to whether any matters not currently under investigation should be opened, whether any matters currently under investigation require further resources, and whether any matters under consideration may merit the appointment of a special counsel. And as you are aware, the Department's Inspector General has an active review of allegations that FBI policies and procedures were not followed last year in a number of matters that you have addressed. And, Mr. Chairman, the letter was addressed to you because it was a response to your letter, and that's how it was sent. And we will make such decisions without regard, hear me, without regard to politics, ideology, or bias. As many of you know, the Department has a long-standing policy not to confirm or deny the existence of investigations. This policy can be frustrating, I understand, especially when there's great public interest about a matter. But it enhances justice when we act under the law with professionalism and discipline. This policy necessarily precludes any discussion on cases I may be recused from, because to do so would confirm the existence of underlying investigations. To the extent a matter comes to the attention of my office that may warrant consideration of recusal, I review the issue, consult with the appropriate department ethics officials, and make my decision as I promised the Senate committee when I was confirmed. Lastly, I would like to address the false charges made about my previous testimony. My answers have not changed. I've always told the truth, and I have answered every question as I understood them to the best of my recollection, as I will continue to do today. I would like to address recent news reports regarding meetings during the campaign attended by George Papadopoulos and Carter Page, among others. Frankly, I had no recollection of this meeting until I saw these news reports. I do now recall that the March 2016 meeting at the Trump Hotel that Mr. Papadopoulos attended, but I have no clear recollection of the details of what he said at that meeting. After reading his account, and to the best of my recollection, I believe that I wanted to make clear to him that he was not authorized to represent the campaign with the Russian government or any other foreign government for that matter. But I did not recall this event, which occurred 18 months before my testimony of a few weeks ago. And I would gladly have reported it had I remembered it, because I pushed back against his suggestion that I thought may have been improper. As for Mr. Page, while I do not challenge his recollection, I have no memory of his presence at a dinner at the Capitol Hill Club or any passing conversation he may have had with me as he left the dinner. All you have been in campaigns, let me just suggest, but most of you have not participated in a presidential campaign, and none of you had a part in the Trump campaign. And it was a brilliant campaign, I think, in many ways, but it was a form of chaos every day from day one. We traveled sometimes to several places in one day. Sleep was in short supply, and I was still a full-time senator with a very full schedule. During this year, I've spent close to 20 hours testifying before Congress before today. I have been asked to remember details from a year ago, such as who I saw on what day, in what meeting, and who said what to when. In all of my testimony, I can only do my best to answer your questions as I understand them and to the best of my memory. But I will not accept and reject accusations that I have ever lied. That is a lie. Let me be clear. I have at all times conducted myself honorably and in a manner consistent with the high standards and responsibilities of the Office of Attorney General, which I revere. I spent 15 years in that department. I love that department. I honor that department and will do my dead level best to be worthy of your Attorney General. So as I said before, my story has never changed. I've always told the truth, and I've answered every question to the best of my recollection, and I will continue to do so today. With that, Mr. Chairman, I'm honored to take your questions.
Well, thank you, General Sessions. We'll now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself. Under your leadership, the prosecution of firearms offenses have increased 23% over the same period of the previous year. Furthermore, the number of defendants charged with using a firearm in violent crimes of drug trafficking rose 10% over the previous year. We have a slide which shows the increase as compared to the Obama-era numbers. What do these increased prosecutions of firearms offenses indicate about the Department of Justice's commitment to fighting violent crime, particularly with the use of firearms, in this country?
Mr. Chairman, as a former federal prosecutor who emphasized gun prosecutions, I've long believed that they have a significant impact in reducing violent crime. Professors earlier this year have explained that they share that view based on scientific analysis. It will be a high priority of ours. You are correct that prosecutions fell. One incident that was raised during the Texas terrific, horrible shooting at the church there in Sutherland, Texas, was the ability of an individual to get a firearm and whether or not they filed correctly their form before you get one. It requires questions about criminal convictions and court-martials. Those prosecutions, I've noticed, have dropped by over 50% in the last 3 or 4 years. I think those are worthy prosecutions. And when a criminal is carrying a gun during a criminal act of some other kind, that is a clear and present danger to the public, and those cases are important in the impact reduction of crime.
As you're aware, I and a majority of the members of this committee have on multiple occasions requested a special counsel to investigate former Secretary Hillary Clinton's mishandling of classified information and the actions of former Attorney General Lynch with respect to former FBI Director Comey's decision not to prosecute former Secretary Clinton. I'm in receipt of the department's letter from yesterday stating that senior federal prosecutors will review our letters and make recommendations as to whether any matters not currently under investigation should be opened, require further resources, or merit the appointment of a special counsel. Do I have your assurance that these matters will proceed fairly and expeditiously?
Yes, you can, Mr. Chairman, and you can be sure that they will be done without political influence, and they will be done correctly and properly.
You also referenced an ongoing Inspector General investigation into many of the matters we have raised. Will you ensure that the IG briefs this committee on his findings in closed session if necessary?
I will do my best to comply with that. The Inspector General is able to announce investigations in a way that we do not on the normal criminal side of the Department of Justice, and I assume he would be able to do that.
Over the past year, we have seen numerous apparent disclosures of unmasked names of U.S. citizens in the context of intelligence reports. Which crimes are violated when these unmasked names are disclosed, for example, to the press? How does the Department of Justice investigate such unauthorized disclosures?
Mr. Chairman, that could implicate a number of legal prohibitions. It could be clearly a release of classified information contrary to law, and it's a very grave offense and certainly goes against the core policies of this government to protect those matters from disclosure. And the second part of your question was
how the department investigates such unauthorized.
We have members of the committee. We had about 9 open investigations of classified leaks in the last 3 years. We have 27 investigations open today. We intend to get to the bottom of these leaks. I think it has reached epidemic proportions. It cannot be allowed to continue, and we will do our best effort to ensure that it does not continue.
And on April 11, you issued a memorandum to all federal prosecutors requesting that they make prosecution of certain immigration offenses a higher priority. To your knowledge, have the number of federal prosecutions increased nationwide for offenses such as harboring aliens, improper entry, and illegal reentry?
I do not have the statistics on that, but I believe there has been some increases in those cases. One thing we've seen is a reduction of attempts to enter the country illegally, and that is good news and should result in some decline in some prosecutions.
And finally, as you know, this committee did a great deal of work to enact criminal justice reform legislation last Congress. Will you continue to work in good faith with me and the members of this committee on both sides of the aisle to identify and craft responsible reforms?
I certainly will, Mr. Chairman.
Thank you, General Sessions. I now recognize the ranking member of the committee, Mr. Conyers, for 5 minutes.
Thank you, Mr. Chairman. And welcome again, Mr. Attorney General. I'd like to begin by putting a few statements by the President up on the screen. The first from July 24, 2017. So why aren't the committees and investigators, and of course our beleaguered Attorney General, looking into crooked Hillary crimes and Russia relations? The second, from November the 3rd. Everybody's asking why the Justice Department and the FBI isn't looking at all of the dishonesty going on with crooked Hillary and the Dems, in quotation. The third, also from November 3rd. Pocahontas just stated that the Democrats, led by the legendary crooked Hillary Clinton, rigged the primaries. Let's go to the FBI and Justice Department. I believe he is referring to Senator Elizabeth Warren in that last one. When Richard Nixon spoke about us that way, at least he had the courtesy to do it behind closed doors. Mr. Attorney General, a few questions for you. Yes or no, please. In a functioning democracy, is it common for the leader of the country to order the criminal justice system to retaliate against his political opponents?
Is that a question?
Yes, that's the question.
Is it proper? Is that what you...
No, you answer to me whether it is yes or no, your response.
But I didn't quite catch the beginning of the question. I'm sorry.
Right. In a functioning democracy, is it common for the leader of the country to order the criminal justice system to retaliate against his political opponents?
Mr. Conyers, I would say that it's the Department of Justice can never be used to retaliate politically against opponents, and that would be wrong.
I interpret that as no.
The answer stands for itself, I guess.
Well, I would just, that would make it a little, easier if you just responded yes or no if you can. Here's another. Should the President of the United States make public comments that might influence a pending criminal investigation?
Should take great care in those issues. Influence, it would be a president cannot improperly influence an investigation.
Okay.
And I have not been improperly influenced and would not be improperly influenced. The president speaks his mind.
Yes,
he's bold and direct about what he says. The people elected him, but we do our duty every day based on the law and the facts.
Reclaiming my time, I'm not impugning these comments to you or what you would do in advance. Last night, sir, the Assistant Attorney General sent the chairman a letter suggesting that the Attorney General has directed senior federal prosecutors to evaluate certain issues, like the sale of Uranium-1 in 2010. Now, at your confirmation hearing, you said, I believe the proper thing for me to do would be to recuse myself from any questions involving those kinds of investigations that involve Secretary Clinton and that were raised during the campaign or to be otherwise connected to it. Now, for my yes or no question, are you recused from investigations that involve Secretary Clinton?
Mr. Chairman, I cannot answer that yes or no, because under the policies of the Department of Justice, to announce recusal in any investigation would reveal the existence of that investigation, and the top ethics officials have advised me I should not do so.
The time of the gentleman has expired. The chair recognizes the gentleman from Wisconsin, Mr. Sensenbrenner, for 5 minutes.
Thank you very much. Welcome, Mr. Attorney General. We're debating whether Section 702 should be reauthorized, and I want to talk about that issue. At the beginning, let me show you a poster that my campaign committee put up on the University of Whitewater campus in the 2014 election during the debate on the USA Liberty Act. And it says, the government knows what you did last night. The NSA has grabbed your phone calls, texts, Facebook posts, and emails. Jim Sensenbrenner thinks that that's an outrageous invasion of your privacy, and it shows that I passed the bill and asked the students to vote for me. It worked. My percentage on that campus went up 20 points from the previous election. Now, we're talking about many of the same issues in terms of Section 702. And the Foreign Intelligence Surveillance Act was designed to collect foreign intelligence, not domestic intelligence. But in reality, we know that a vast number of Americans' communications are also collected. The committee took a great step in trying to balance security and privacy last week when we reported out the USA Liberty Act, which made significant changes to the program. But notably, this legislation specifies two ways the government can query the information under Section 702, either foreign intelligence or evidence of a crime. The USA Liberty Act ensures that the government does not abuse 702 by requiring that a warrant be issued to access content after querying information for evidence of a crime. Now, Attorney General Sessions, you have stated on several occasions that you believe that a warrant requirement would hinder the government's ability to detect and stop terrorists. Yet this bill already provides the government to move forward without a warrant on foreign intelligence in an emergency situation. Why can't the USA Liberty Act be the compromise? Can't we allow the intelligence community to stop terrorists while protecting the constitutional rights of Americans?
Well, we can. And the constitutional rights of Americans should be protected. And I know you worked on the Patriot Act when it came up with Senator Hatch and Senator Leahy and others. And I know you're a champion of civil liberties. So I would just say that we can do that. The act as written, as in law today, has been approved by the courts and has not been found to be in violation of the law. And so that's first and foremost. I know the committee has decided to put some additional restrictions on the way the act is conducted. We did not think that was lawfully required. Congress can make its own decisions, and we'll continue to be able to share our thoughts about how the legislation should be crafted.
Well, Mr. Attorney General, the day before the committee marked up this bill, the Justice Department was actively lobbying members of the committee to oppose the measure, stating that it would dismantle Section 702. Now, this is a huge gamble because 702 expires at the end of the year. We have a very short timeline, and I want to ask you, whether yes or no, following my friend from Michigan, do you want to risk the real possibility that this program will expire by insisting upon a clean reauthorization without a sunset?
No, we don't want to take that risk.
Will you commit to working with Congress and not against us to make sure that Section 702 is reauthorized, either the way you want it or the way we want it?
I almost said Mr. Chairman. I know you've held that office. Yeah. Congress gets to dispose. We get to give our opinion. I believe the act as passed, and it has been reauthorized with an even larger vote last time, is constitutional. I believe it works, and I am worried about additional burdens, particularly a warrant requirement, which could be exceedingly damaging to the effectiveness of the act. We're willing to talk to you about some of the concerns that exist out there. Hopefully we can work our way through it and accept the concerns and fix the concerns you have without going too far.
With all due respect, there is an emergency exemption in the USA Liberty Act as reported from the committee, and that should take care of the problem. And yet people in your department were saying this was no good. You know, I take your offer, you know, at face value, and I will let you know if I hear of members of your department actively lobbying to defeat the bill rather than
The chair recognizes the gentleman from New York, Mr. Nadler, for 5 minutes.
Thank you, Mr. Attorney General. Following up on the questions from Mr. Conyers, at your confirmation hearing, you said, I believe the proper thing for me to do would be to recuse myself from any questions involving these kinds of investigations that involve Secretary Clinton and that were raised during the campaign or to be otherwise connected to it, close quote. Do you stand by that statement, yes or no?
Yes.
Thank you. Now, I want to show you an image from March 31st, 2016, of a meeting of the Trump Campaign National Security Advisory Committee, which you chaired, with yourself in attendance, along with then-candidate Donald Trump and Mr. George Papadopoulos. Mr. Papadopoulos pled guilty on October 5th to making false statements to the FBI. The charging papers filed by Special Counsel Mueller described the March 31st meeting where Mr. Papadopoulos told the group that he had connections and could help arrange a meeting between Donald Trump and Vladimir Putin. After the meeting, Mr. Papadopoulos continued to communicate with the Russian government on behalf of the Trump campaign and appears to have told several senior campaign officials about it. Now, here's the problem. On October 18th of this year, you said under oath in front of the Senate Judiciary Committee, quote, a continuing exchange of information between Trump surrogates and intermediaries for the Russian government did not happen, at least not to my knowledge and not with me. Senator Franken asked, you don't believe that surrogates from the Trump campaign had communications with the Russians, to which you responded, I did not, and I'm not aware of anyone else that did, unquote. Now, we now know that, one, the campaign had communications with the Russians through Mr. Papadopoulos and others, and two, you seem to have been aware of the fact at the time. So let's try and correct the earlier testimony now for the record. Yes or no? Did you chair the March 31st, 2016 meeting of the National Security Advisory Committee?
I did chair that meeting.
Thank you. Yes or no? Did Mr. Papadopoulos mention his outreach to the Russian government during that meeting?
He made some comment to that effect,
Yes.
as I remember
Right. I don't
after
have
having
to.
read
I
it
asked for
in the
yes or-
newspaper.
I asked for yes or no. I don't have time.
Yes, all right.
There are reports that you shut George down, unquote, when he proposed that meeting with Putin. Is this correct, yes or no?
Yes. I pushed back, I'll just say it that way, because it was...
Yes. Your answer is yes. So you were obviously concerned by Mr. Papadopoulos' connections and his possibly arranging a meeting with Putin. Now, again, yes or no, did anyone else at that meeting, including then-candidate Trump, react in any way to what Mr. Papadopoulos had presented?
I don't recall.
Okay. So your testimony is that neither Donald Trump nor anyone else at the meeting expressed any interest in meeting the Russian president or any concerns about communications between the campaign and the Russians?
I don't recall it.
Okay. Now, we know from multiple sources, including the Papadopoulos guilty plea, Carter Page's interview with the Intelligence Committee, and Donald Trump Jr.'s emails, among others, that contrary to your earlier testimony, there were continued efforts to communicate with the Russians on behalf of the Trump campaign. We have established that you knew about at least some of these efforts. They caused you such concern that you, quote, shut George down. I want to know what you did with this information. Yes or no? After the March 31st meeting, did you take any steps to prevent Trump campaign officials, advisors, or employees from further outreach to the Russians?
Mr. Nadler, let me just say it this way. I pushed back at that. You made statements that he did, in fact, at the meeting. I pushed back.
We know that. But did you, after the
No,
meeting?
I'm not. I have to be able to answer. I can't be able to
I'm
be put in a
asking you,
position
yes,
where
I
I
only have
can't
5
explain.
minutes. I'm asking you.
I'm not going to be able to answer if I can't answer completely.
But you said you pushed back. We accept that. After the meeting, did you take any further steps to prevent Trump campaign officials, advisors, or employees from further outreach to the Russians after you stopped it or pushed back at that meeting?
What I want to say to you is you allege there were some further contacts later. I don't believe I had any knowledge of any further contacts, and I was not in regular contact with Mr. Papadopoulos.
So your answer is no, because you don't think there were any such contacts. So you
I'm not aware of it.
Okay. So I was going to ask you a question of did you raise the issue with various people, but your answer is no.
To the best of my recollection.
Okay. So your testimony today is that you communicated with nobody in the campaign about this matter after the March 31st meeting because nothing happened.
Repeat that.
Your testimony, therefore, is that you communicated with nobody in the campaign about this matter after the March 31st meeting.
I don't recall it.
You don't recall. At some point, you became aware that the FBI was investigating potential links between the Trump campaign and the Russian government. After you became aware of the investigation, did you ever discuss Mr. Papadopoulos' effort with anybody at the FBI?
Did I discuss the matter with the FBI
Yes.
to ask them questions about what they may have
You
found?
discussed the Papadopoulos question with the FBI.
I have not had any discussions with Mr. Mueller or his team or the FBI concerning any factors with regard to this
Nobody else at the
investigation.
FBI either?
No.
At the Department of Justice?
No.
At the White House?
No.
Any member of Congress?
Well, I don't know if these conversations may have come up at some time, but not to obtain information.
Okay.
With regard to your broad question, I don't recall at this moment, sitting here, any such discussion.
I have one
It's
further-
important for me to say
I
that.
have
The
one
time of the
further
gentleman has expired. We've got a lot of people waiting to ask questions, and the chair recognizes the gentleman from Ohio, Mr. Shabbat, for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, does your recusal from investigations related to the interference by Russia in the 2016 presidential campaign apply to any investigations regarding efforts by the Democratic National Committee and the Clinton campaign to secretly fund a scurrilous and widely discredited dossier on candidate Donald Trump?
Mr. Chabot, anything that arises in this nature that may be or may not be connected to my recusal on the question of the campaign in Russia would be discussed between me, the senior ethics advisor at the Department of Justice, and that's how I make my decision. That's what I promised to do when I was confirmed before the Senate Judiciary Committee, and that's what I will do. And I'm unable to provide information to you as to what decision has been made in this matter.
Great. Thank you very much. I'm not and never was a prosecutor, but I did some criminal defense work back in the day when I practiced law for almost 20 years. It seems to me that a presidential campaign using a law firm as a conduit to pay for activities with which the campaign itself doesn't want to be directly associated is more than just dirty politics. It's also quite possibly illegal. To me, it seems that this is at least a violation of campaign finance laws for failure to accurately disclose the actual recipients of campaign disbursements. However, this type of arrangement is not illegal. If it's not illegal under current law, I fear that we're risking opening Pandora's box with all sorts of underhanded activities by campaigns being laundered through law firms and shielded under attorney-client privilege. As the chief law enforcement official in this country, do you share similar concerns? And in your opinion, is it legal under current law for a presidential campaign to hide its funding of the compilation and dissemination of political dirt on its opponent by using a law firm to directly pay for the work?
I would think that those matters are worthy of consideration, but as to the details of them and for me to express an ultimate comment today, I'm unable to do so.
Okay. Thank you. Let me shift over to something entirely different. Federal law currently still cites marijuana as a dangerous drug. It's still prohibited. It's still illegal under federal law. Yet a number of states have, for both medical purposes and now even for recreational purposes, have basically made it legal. What is your department's policy on that relative to enforcing the law?
Our policy is that the same really fundamentally as the Holder-Lynch policy, which is that the federal law remains in effect and a state can legalize marijuana for its law enforcement purposes, but it still remains illegal with regard to federal purposes.
It seems to me that there's always been a tremendous amount of gray area in that whole field, which I think as a nation, we need to look much more closely at, both from the state's point of view and the federal government point of view. But that's just my feeling on that. Running out of time, I had about 4 other things, but let me just go to one final thing here. I've been very involved in the area of victims' rights. I was following Henry Hyde's leadership on this, introduced the Victims' Rights Constitutional Amendment years back, various pieces of legislation on victims' rights. And I've also worked closely with the parents of murdered children. And when you talk about something that affects one's family, there's nothing that affects a family more adversely than something like that happening. And we still have capital punishment on the books, both at the federal level and many of our states, yet these families are dragged left and right, up and down, back and forth into hearing after hearing. These cases can drag on for more than 20 years before the imposition of capital punishment actually occurs, and in many instances, obviously, it never does. And while these people are behind bars, oftentimes they attack, sometimes kill guards, sometimes kill other inmates. So what is, I'd be interested to see, what is your intentions relative to capital punishment in this country?
Well, many states have capital punishment. The federal government has capital punishment for a number of offenses, and is specifically controlled. We have within the department a recommendation process through an appointed committee to seek or not seek a death penalty when a case is charged. Sometimes it's a complex thing, but I believe the death penalty, the federal death penalty, is a part of our law. I think it's a legitimate penalty. It's constitutional, and we will do our duty even in those circumstances that require the imposition of the death penalty.
Thank you very much. My time's expired.
The chair recognizes the gentlewoman from California, Ms. Lofgren, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Attorney General, for being here today. Former National Security Advisor Michael Flynn is under investigation because of his work and ties to foreign governments. According to various reports, much of his work with these foreign governments went unreported when Mr. Flynn was required to make certain disclosures by law. Now, as chairman of the Trump campaign, National Security Advisor Committee and lead advisor on the Trump transition team, I think you worked closely with Mr. Flynn, and I'd like you to answer a few yes or no questions about Mr. Flynn. And knowing that Mr. Flynn is under investigation, I'm going to stick to subject matter that predates both the special counsel's investigation and your appointment as Attorney General. Now, the foreign policy platform at the Republican National Convention undertook dramatic changes. Did you discuss changes to the Republican foreign policy platform with Mr. Flynn at any point during the campaign?
I don't recall it. I was not at the convention when the platform committee met.
You were the lead of the campaign, but you don't recall discussing it with him?
Well, that may be a bit of a stretch. I was asked to lead, inform, and find some people who would join and meet with Mr. Trump to give him advice and support regarding foreign policy, and I did so, although we were not a very effective group, really.
You met with Ambassador Kislyak in November of 2016. Did you discuss your meetings with Ambassador Kislyak with Mr. Flynn?
Did I discuss Mr. Flynn with him?
Did you discuss your meeting with the ambassador with Mr. Flynn?
The ambassador, I met with, I think, some 25 ambassadors that year. I did meet once in my office with Mr. Kislyak, and I do not recall and don't believe I communicated any of that information to Mr. Flynn.
Are you aware of any meetings between Ambassador Kislyak and Mr. Flynn that might have occurred around the time of your meeting with the ambassador?
I do not.
Okay. In her testimony before the Senate in May, former acting Attorney General Sally Yates testified that 1 week into the Trump administration, she notified the administration that Mr. Flynn had lied to Vice President Pence about discussing sanctions with Ambassador Kislyak. As part of the transition team and the president's pick for Attorney General, in January, were you notified when the administration was notified of Mr. Flynn's lie and his susceptibility to Russian blackmail?
I don't believe so.
All right. We now know that you were aware of the efforts of Carter Page and George Papadopoulos to meet and establish communications with the Russian government. Did you at any point...
Well, that's not necessarily so, about, at least from what Mr. Carter Page says, and I don't recall that.
All right. Did you at any point discuss with Michael Flynn the possibility of then-candidate Trump or his surrogates meeting with the Russian government?
I do not recall such a conversation.
Did you know that Flynn was working for the Turkish government while acting as a surrogate for the Trump campaign?
I don't believe I had information to that effect.
Did you know that he was working for the Turkish government at any point after the election?
I don't believe so.
Were you or anyone on the Trump campaign aware of Mr. Flynn's efforts to extradite Turkish cleric Gulen?
I've read that in the paper recently, but I don't recall ever being made aware of that before this recent release in the paper.
So you just read about it in the newspaper afterwards? After the inauguration, you did not know that the FBI was requested to conduct a new review of Turkey's 2016 extradition request for Mr. Gulen?
The FBI was...
Did you know about that?
I'm aware that the Turkish government continued to press the federal government with regard to seeking the return of Mr. Gulen to Turkey.
Did you know
and our department had a role to play in that, although I'm not at liberty to discuss the details of that.
Did you know that the Turkish government allegedly offered $15 million for Mr. Flynn to kidnap Mr. Gulen?
Absolutely not. You mean it? No.
On
Time of the gentlewoman has expired. The chair recognizes the gentleman from Iowa, Mr. King, for 5 minutes.
Thank you, Mr. Chairman, and thank you, General Sessions, for your testimony here today and your service to our country over the years that you have been front and center. And a number of things I wanted to discuss. One of them is the DACA situation. And it seems, as I recall, that you had made a public statement some time back about the constitutionality of the policy that was implemented by President Obama. Would you care to reiterate that position today?
Well, the president, President Obama indicated multiple times that he felt that DACA, he didn't have the power to do DACA in the way it was done. And eventually they must have changed their mind and executed this policy to take persons who are in the country unlawfully and to give them lawful status, work permits, and even participation in Social Security. So I felt for some time that that was not proper. A federal district court in Texas so held, and the Fifth Circuit Court of Appeals also so held that it was unlawful. So what happened was we helped work on the research, but the Department of Homeland Security withdrew the policy because it was not defensible in my view.
And established a date to close it down of March 5th, I think, of next year?
That's right. The Homeland Security asked for time to wind this program down, and I thought that was appropriate.
And there's a lot of public dialogue about what kind of legislation might be passed in conjunction with the DACA policy. And that's up in the air right now. I'm noticing that Democrats are saying we're going to have everything we want on DACA or we'll shut the government down. So it causes me to think about what should happen if Congress reaches an impasse and there is no passage of any legislation to extend the DACA policy. If the president should decide on or before that March 5th date, around that period of time, that he wants to extend the DACA policy, what would your position be at that time?
Well, that's hypothetical, Senator King. I don't think I should speculate on that, but I do think Congress will have to give it thought. We have a law now; it's in place. It's Congress passed, and Congress would have to change it.
And I would just remark that I'm watching a lot of people be rewarded for violation of the rule of law, and I appreciate your emphasis on rule of law in your testimony today, multiple times coming back to that point.
Mr. King, I would just say it is correct in my view, and I think you probably share it, that something is lost whenever you provide an amnesty. It's a price will be paid if that's done, but sometimes circumstances are such it may need to be done, but we need to be careful.
Thank you. And we've been made aware here in this committee that there's a significant backlog in immigration cases. Have you presented any request to Congress or a statement that could inform us as to how many resources you might need, how many judges you might need to get this backlog caught up, and then an idea how many we might need to maintain an anticipated level?
That's a very good question. Yes, we've worked on it. We have some preliminary information. We're seeking a total of about 360, 70 judges. We've added about 50 to the total. We've shortened the time process for selecting people, not shortening the training program, and we're adding judges. I would say on the backlog, it's gone up dramatically. It's now over 600,000. But the last 2 or 3 months, we're almost not adding to the backlog. And I'm told by the additional work we're doing by January, we will not be adding to the backlog, but hopefully reducing it. That would be a real change in the trends that we were heading on.
Well, thank you. Then I just ask you to reflect as this committee anticipates the potential of a special counsel to broaden this look that I think is forced upon us in a reluctant way, but I certainly support that special counsel to look back at some times here that I believe should be incorporated into this, and that is I look back at October 16th, 2015, when Barack Obama was speaking of Hillary Clinton and whether she might have violated any security clauses in our statute, and in particular 18 U.S.C. 793, when he said that he had no impression that Mrs. Clinton had purposely tried to hide something or to squirrel away any information, made the point of intent. Behind that, in April after that, April 10th, a similar statement. She would never, meaning Hillary Clinton, she would never intentionally put America in any kind of jeopardy. Those words of intent caught my attention when I heard James Comey use that very word July 5th of 2016, and it seems as though he latched on to the statements made by President Obama, and they more or less implied and implemented it into an interpretation of the statute, that word intent, as if it were a condition before there could be any prosecution for a violation of 18 U.S.C. 793. And I don't know that I have a question on that. I want to make sure that I put that into the record so that it's under consideration by the DOJ.
Time of the gentleman has expired. Chair recognizes the gentlewoman from Texas, Ms. Jackson Lee, for 5 minutes.
I thank you very much. Mr. General, do you believe in this book, the Constitution of the United States?
Yes.
And will abide by it with all of your intentions?
That's exactly correct.
I thank you so very much. I took the liberty of reviewing federal crimes against children, particularly those dealing with sexual or physical abuse. As you well know, Lee Kaufman, Wendy Miller, Debbie Watson Gibson, Gloria Thacker Deason, and Beverly Young Nelson, these young women, have accused this individual, Judge Moore, who is running for a federal office, the United States Senate, of child sexual activity. Do you believe these young women?
I have no reason to doubt these young women.
And with that in mind, if you believe these young women, do you believe Judge Moore should be seated in the Senate if he wins, and would you introduce investigations by the DOJ regarding his actions?
We will evaluate every case as to whether or not it should be investigated. This kind of case would normally be a state case. I would say, Representative Jackson Lee, that the ethics people at the Department of Justice, and I've talked to them about that when this campaign started. It's the seat I used to hold. They advised me that the Attorney General should not be involved in this campaign. I have friends in the campaign.
Thank you, Mr. General.
I have steadfastly adhered
I want to make sure that if he
view,
comes to the United States Senate,
I think I should continue to do so.
If he comes to the United States Senate, that there would be the possibility of referring his case for at least a federal review by the Department of Justice.
We will do our duty.
Let me also refer you back to the meeting on March 31st, 2016 with Mr. Papadopoulos. You well know that Mr. Papadopoulos, in addition to his comments in the meeting regarding a meeting between Trump and Mr. Putin, had series of meetings dealing with, and as you can see, Trump, Mr. Papadopoulos, and you leading that committee. I cannot imagine your memory would fail you so much. But moving on, he was in that meeting, but you also had Stephen Miller, who is a senior policy advisor, who was noted in the stipulated statement of offense to receive conversations from Mr. Papadopoulos about his constant interaction with the Russians to intrude in the 2016 election. You continued in the October 18th meeting before the Judiciary Committee, or hearing in the Senate, to not answer the question. Now, in light of the facts that are now part of the record, do you wish to change your testimony before the Senate Intelligence Committee on June 13, 2017, where you said, I have never met with or had any conversation with any Russians or any foreign officials? Let me jump to the final part.
Well,
I have no knowledge of any such conversations by anyone connected to the Trump campaign. Do you want to admit under oath that you did not tell the truth or misrepresented, or do you want to correct your testimony right now?
You're referring to my testimony at confirmation?
Before the Senate Intelligence Committee, my time is short, and I have two more questions, please.
Well, I'm not able to respond because I don't think I understand what you were saying.
I'm asking your Intelligence Committee testimony. Do you want to change it where you indicated you had no knowledge of involvement of the Trump individuals involved in conversations regarding the Trump campaign Russians? And Mr. Miller supported Mr. Trump's press conference where he said, Russia, if you're listening, I hope you'll be able to find the 30,000 emails. Do you want to change your testimony that was where you said I have no knowledge of any such conversations by anyone connected to the Trump campaign regarding Russians involved in the campaign? That was a testimony on June 13th.
I'm not able to understand.
All right, let me move forward to the
Let me say this, Mr. Chairman. Could I?
The black identity, let me move to a document that you have prepared. The gentleman keeps saying he cannot recall, so I'm reclaiming my time.
The gentleman will suspend. The witness wants to answer the question she asked.
And I should be given extra time, and I do not have extra time. Let me move to the black identity.
The gentleman will suspend.
I will
suspend. The witness will answer the question.
Yes or no? Does he want to change his testimony in the Intelligence Committee?
I would just say this. I stand by this testimony at the Intelligence Committee. I have never met with or had any conversation with any Russians or any foreign officials concerning any type of interference with the campaign or election in the United States. Further, I have no knowledge of any such conversations by anyone connected to the Trump campaign.
Thank you very much for that.
What I did say in my opening statement, I explained that when I was asked in October, just a few weeks ago, when I was asked about the matter, did I have any knowledge of anyone who had talked to the Russians, I indicated that I had not recalled that meeting when that occurred. But I would have been pleased to have responded and explained it if I'd recalled it. I've tried to be honest about that and give you my best response and did throughout all the testimony I've given, Ms. Lee.
You stand by your testimony. Thank you very much. Are you familiar with the names Eric Garner, Walter Scott, Jameer Rice? My question is, as I hold up the poster dealing with the report under your jurisdiction, Black Identity Extremists, it is interesting to me that you are opposing individuals who are opposing lethal force, similar to the attack on Reverend Dr. Martin Luther King on COINTELPRO, but there seems to be no report dealing with the Tiki Torch Parade in Charlottesville chanting, Jews will not replace us. Why is there an attack on black activists versus any reports dealing with the alt-right and the white nationalists? Can you answer that question quickly?
I'm not aware.
Are you planning on investigating that?
When was that report completed?
In August of 2017.
I'm not aware of. I have not studied that report.
I ask you to because it's an attack on individuals who are simply trying to petition the government in a redress of grievances. Let me move to criminal justice reform. We have found that mandatory minimums and over-incarceration has been the history of criminal justice. We were moving toward criminal justice reform, which you opposed as the United States Senator, and now you intend to return toward discredited Nixon-era law and order criminal justice policies going to make America great or waste precious taxpayer dollars. Do you have any interest in rehabilitating those incarcerated, recognizing that mandatory minimums created the opportunity for over-incarceration rather than telling your prosecutors to prosecute on every single crime? Is there any opportunity to work with your office to deal with progressive ways of dealing with criminal justice reform at this time? Yes or no?
Yes.
Right?
I would just respond and say that Senator Durbin and I worked together to reduce the crack cocaine penalties some years ago. It probably remains the largest.
You pull back
single
on
the time of the gentlewoman has expired. The witness is allowed to answer the last question.
Minimums.
I'm sorry.
Time of the gentlewoman has expired. The chair recognizes the gentleman from California, Mr. Issa, for 5 minutes.
Thank you, Mr. Chairman. General Sessions, it's good to see you again.
Yes, sir.
I don't speak Russian, and I don't meet with Russians, and I don't really want to ask about those questions today, but I do have some very important questions.
Well, Congressman Issa, you said that, but I bet you have met with some Russian, and if you, in your lifetime, and taking those words at face value, somebody might accuse you of not being honest.
You're absolutely.
That's what they've done to me.
You're absolutely right, General Sessions. That is the challenge. Is that as a member of the Foreign Affairs Committee, I meet with lots of ambassadors and I don't want to try to remember everyone and everything that was discussed in what I thought was a pro forma meeting. But there are a couple of areas that are left over from the previous administration that I'd like to talk to you about. One of them is we sent Loretta Lynch, General Lynch, a letter related to sober homes and a predicament. And the predicament is fairly straightforward. If and her answer, to be honest, to Chairman Goodlatte and the rest of us was not satisfactory, and we've given your staff a copy of it. Essentially, sober living homes are nothing but boarding houses. They're required to provide no care whatsoever to the alcoholic or recovering drug abuser because that has to be done somewhere else, or they don't qualify as sober homes. And yet, currently, there is, in the Ninth Circuit, decisions that cause cities to be unable to regulate them in a way that would prevent people from simply buying houses in a row in a very prestigious neighborhood and turning them into these, if you will, sober living homes, which are, again, boarding houses with 15 or more people. Will you agree to work with us to try to find an appropriate way to align your enforcement of the Americans with Disability Act and your enforcement of the Fair Housing Act with the necessity for cities to be able to essentially regulate how many people live in a home?
Yes, I would be pleased to do that. These are important issues because a lot of money is being spent and some of it not wisely in these areas.
A lot of it is federal dollars being squandered to the benefit of people that are speculating. The second one is in a trial court ruling in the Durante Nursery versus the Army Corps of Engineers case. Are you even familiar with this case?
I'm not.
Well, I'd like you to become familiar because during your administration, a assistant U.S. attorney on your behalf argued that the waters of the U.S., which is not a valid regulation delivered to Congress and eligible under CRA to be considered or rejected, continued to argue that that was law. Would you agree that your attorneys on your behalf should not argue regulations which have not been delivered to Congress and as a result are not eligible for CRA review?
Mr. Issa, I have now recalled the case. I didn't recall it by name. That matter was intensely reviewed by a new Assistant Attorney General for the acting, at least for the Environment and Natural Resources Division. After great consideration, we felt it was advised to me, and I approved going forward with that position in court. So I will take responsibility for it, but I got to tell you, we did look at it very hard.
But in general, you would agree that if a regulation is created or some other words of the executive branch, they don't have the weight of law unless they're delivered to Congress, so we have an opportunity to review them under the Congressional Review Act.
That would sound correct.
Thank you. My last question is less of a softball, and neither one of these are softball. They're very important to California. But in a previous Congress, the Ways and Means Committee of the United States House voted for and referred criminal charges against Lois Lerner. I also was involved in investigating her wrongful activity. They referred criminal charges, and they did so under a statute that says, and I'll paraphrase it as well as I can, that the U.S. Attorney for the District of Columbia shall present to the grand jury the following, and then they laid out the criminal charges. The previous Attorney General ordered the U.S. Attorney or U.S. Attorney in district made a decision not to enforce that. Now, the statute, as we understand it, is not a statute that says you will look at this and decide independently. It actually says it shall be presented to the grand jury. Will you commit to review that? And if you agree with us as to what the statute says, and we think it's pretty plain English, order a U.S. attorney to present to a grand jury, and if they no-bill it, fine, but in fact to present it consistent with congressional and statutory law.
I will review that more personally, but the Department of Justice view has been it takes a full vote of the House to accomplish that act, and I'm not sure where that leaves us, but I will give it a personal review, which I have not done.
Mr. Chairman, if you can stop the clock for just 1 second. If the entire House voted to
the time of the
go after
gentleman,
the U.S. The
time of the gentleman has expired. The chair recognizes the gentleman from Tennessee, Mr. Cohen, for 5 minutes.
Thank you, sir. Mr. Attorney General, first, I noted you went to the 50th anniversary of the Selma, Alabama March, Selma, Montgomery. I commend you for that, and you were a sponsor of the gold medal for those folks that marched. Having done that, I would like to ask you, what have you done as Attorney General to see to it that African Americans and others who have been discriminated for years in voting have more access to the ballot box?
We will absolutely, resolutely defend the right of all Americans to vote, including our African American brothers and sisters. It cannot ever be suggested that people are blocked from voting. And we have done a number of things in the Department of Justice.
Let me ask you this, Mr. Attorney General. It's a fact, there have been studies to show that voter ID is more discriminatory in its effect on African Americans and Latinos than anything else. Will you stop in defending voter ID law cases?
No. The Supreme Court has approved voter ID if properly done. Other courts have too. It can be done in a discriminatory way, which is not proper and should not be approved. But I believe it's settled law that a properly handled and written voter ID law is
Let me
lawful.
suggest to sir, with all due respect, we come from the similar region. I think we have a greater responsibility than anybody else in this country to see to it that African Americans get a chance at the ballot. When they were discriminated against, they were slaves for 200+ years, they were under Jim Crow, they weren't allowed to vote, and they're still being discriminated against. And I would submit to you and ask you to look at voter ID laws, access to the ballot, election day voting, early voting, and other indices that will allow people to vote that have been stopped. Secondly, on marijuana, you said that you are basically doing the same as Holder and Lynch. I believe General Holder and General Lynch abided by congressional appropriations that limited the Justice Department in enforcing marijuana laws where states had passed laws on medical marijuana and others. Will you abide by congressional appropriations limitations on marijuana when they conflict with state laws?
I believe we're bound by that.
Thank you, sir. That's great. That's great. And I saw what you did on crack cocaine was good. It wasn't as good as it could have been. Your proposal was a 20-to-1 ratio. Mr. Durbin's was a 10-to-1 ratio. Y'all decided on 18-to-1. You were a good negotiator, but Mr. Durbin took what he could get. But it should have been 1-to-1. But you admitted in that hearing that it could discriminate against the disparity against African Americans and minorities, and you ought to look at that.
I would just say that the net effect of that legislation was to significantly reduce the penalty one is subjected to for dealing with crack cocaine.
Yes, sir, and that was good.
That may be a better analysis than the 18-to-1 or whatever it is. It's generally considered a more dangerous drug.
Marijuana is not as dangerous as heroin. Would you agree with that?
I think that's correct.
Well, thank you, sir. I would hope that in your enforcement that you would look at the limitations you've got. There's always an opportunity cost, and put your opportunity cost, your enforcement on crack, on cocaine, on meth, on opioids, and on heroin. Marijuana is the least bothersome of all. 28 states or 29 states in the District of Columbia have legalized it for medical purposes. 8 states in the District of Columbia for recreational purposes. Justice Brandeis famously said that the states are the laboratories of democracy. I would hope you'd look at marijuana and look at the states as laboratories of democracy and see how they've helped. In states where they've got medical marijuana, they have 25% less opioid use. It gives people a way to relieve pain without using opioids, which inevitably leads to death and crime. And so I would hope you take a look at that.
We will take a look at it, and we'll be looking at some rigorous analysis of the marijuana usage and how it plays out. I'm not as optimistic as you.
You said one time that good people don't smoke marijuana. Which of these people would you say are not good people?
Well, let me explain how that occurred.
All right.
And I explain
quickly.
John
Kasich a good person? George Pataki, Rick Santorum, Newt Gingrich, Ted Cruz, Jeb Bush, George Bush, Arnold Schwarzenegger, or Judge Clarence Thomas? Which of those are not good people?
Let me tell you how that came about, Congressman. So the question was, what do you do about drug use, the epidemic we're seeing in the country, and how you reverse it? Part of that is a cultural thing. I explained how when I became United States Attorney in 1981, and the drugs were being used widely, over a period of years, it became unfashionable, unpopular, and people were seen, and it was seen as such that good people didn't use marijuana. That was the context of that statement.
It might have affected
Time
my
of the
short-term
gentleman
memory.
has
What
expired.
years were those?
Chair recognizes the gentleman.
One last
Mr.
question,
Jordan.
Alabama or Auburn?
The gentleman.
War Eagle.
Time has expired. No.
Although I went to law
Chair
school,
recognizes the
I love
gentleman from Ohio,
Alabama.
Mr. Jordan, for 5 minutes.
Mr. Attorney General, did the FBI pay Christopher Steele?
Where am I?
Right here.
Yeah.
Did the FBI pay Christopher Steele, the author of the dossier?
Those are matters you'll have to direct to the, I think maybe the special counsel.
And why is that? I'm just asking if someone
Well, I'm
was on
not
the payroll
able
of the
to
FBI.
reveal internal investigatory matters here that's under the investigation of anybody, but particularly I think
This happened in the summer of 2016. We know the Clinton campaign, the Democrat National Committee paid through a law firm, Fusion GPS, to produce the dossier. We know the author was Christopher Steele. It's been reported that he was on the payroll of the FBI. I'm just wanting to know if, in fact, that is the case.
I'm not able to provide an answer to you.
Did the FBI present the dossier to the FISA court?
I'm not able to answer that.
Do you know if the FBI did the established process protocol in evaluating claims made in the dossier?
I'm not able to answer that.
On January 6, then FBI Director James Comey briefed President-elect Trump up in New York about the dossier. Shortly thereafter, the fact that that meeting took place and the subject of the meeting was the dossier was leaked to CNN. Do you know who leaked that information?
I do not.
Are you investigating who leaked that information?
That would be a matter within the investigatory powers of the special counsel.
You said you got a number of
Department
investigations going on, Mr. Attorney General, regarding leaks. Is that likely one of those that you're investigating?
I'm not able to reveal the existence of investigations or not.
Mr. Attorney General, I appreciate your service in the Senate. I appreciate your service at the Justice Department. Consider you a friend. And frankly, I appreciate yesterday's letter saying you were considering appointing a special counsel that you sent to us. But my concern is we sent you a letter 3.5 months ago asking for a second special counsel. And if you're now just considering, what's it going to take to get a special counsel? We know that former FBI Director James Comey misled the American people in the summer of 2016 when he called the Clinton investigation a matter. It's obviously an investigation. We know FBI Director Comey was drafting an exoneration letter before the investigation was complete. We know Loretta Lynch, 1 day before the Benghazi report came out, 5 days before Secretary Clinton was scheduled to be interviewed by the FBI, met with former President Bill Clinton on a tarmac in Phoenix. We know after that meeting, when she was corresponding with public relations people at the Justice Department, she was using the name Elizabeth Carlisle. You know, as I've said before, it seems to me if you're just talking golf and grandkids, you can probably use your real name. We know that Mr. Comey publicized the investigation, and we know he made the final decision on whether to prosecute or not. And then when he gets fired, he leaks a government document through a friend to the New York Times, and what was his goal? To create momentum for a special counsel, and of course it can't just be any special counsel, it's got to be Bob Mueller, his best friend, his predecessor, his mentor. The same Bob Mueller who was involved, we've now learned, in this whole investigation with the informant regarding Russian businesses wanting to do business in the uranium business here in the United States regarding the Uranium One deal. So I guess my main question is, what's it going to take, if all that, not to mention the dossier information, what's it going to take to actually get a special counsel?
It would take a factual basis that meets the standards of the appointment of a special counsel.
Is that analysis going on right now?
Well, it's in the manual of the Department of Justice about what's required. We've only had two. The first one was the Waco, Janet Reno, Senator Danforth, who took over that investigation as special counsel, and Mr. Mueller. Each of those are pretty special factual situations.
Let me ask it this
way. And
way.
we will use the proper standards, and that's what only thing I can tell you, Mr. Jordan.
Well, I appreciate
you can
that.
have your idea, but sometime we have to study what the facts are and to evaluate whether it meets the standard
well said.
that
So let me ask you
requires
this. If in fact,
a special counsel.
Well, we know one fact. We know the Clinton campaign, the Democrat National Committee paid for, through the law firm, paid for the dossier. We know that happened. And it sure looks like the FBI was paying the author of that document, and it sure looks like a major political party was working with the federal government to then turn an opposition research document, the equivalent of some National Enquirer story, into an intelligence document, take that to the FISA court so that they could then get a warrant to spy on Americans associated with President Trump's campaign. That's what it looks like. And I'm asking you, doesn't that warrant, in addition to all the things we know about James Comey in 2016, doesn't that warrant naming a second special counsel, as 20 members of this committee wrote you 3.5 months ago asking you to do?
Well, Mr. Comey is no longer the director of the FBI.
Thank goodness.
We have an excellent man of integrity and ability in Chris Wray, and I think he's going to do an outstanding job, and I'm very happy
He's
about
not here today,
that.
Attorney
And
General.
I would say,
you are, and I'm asking for a special counsel.
The time of the gentleman
and I would
has
say
expired.
looks like is not enough basis to appoint a special counsel.
Time of the gentleman has expired. The chair recognizes the gentleman from Georgia, Mr. Johnson, for 5 minutes.
Thank you, General. You have led a remarkable and notable career over the last 42 years as an attorney in private practice, as the Attorney General of Alabama, then the U.S. Attorney in Alabama, later the U.S. Senator of Alabama, and now the Attorney General of the United States of America. And you made a professional judgment call when you recused yourself from the investigation of the Russian interference in the 2016 elections, and you've caught a lot of flack for that decision. What I want to know is, why did you recuse yourself?
Well, thank you very much. I told the Senate Judiciary Committee when I was confirmed that I would evaluate those matters. I would seek the counsel of the senior ethics advisor.
My question is, why did you recuse yourself?
I'll get that.
So I don't want you to filibuster.
Okay.
So
I did do that. I evaluated that, and they showed me something I was not familiar with. One of the Code of Federal Regulations that says if you participate in a substantial role in a campaign, a Department of Justice employee should not participate in investigating that campaign.
Thank you.
I felt that was correct. It was not because I had any concern about anything I had done previously, but it was, to me, if I were not bound by that, I don't see how other people in the Department of Justice could be expected to follow the rules of the department either.
Well, thank you, sir. And after you recused yourself, you did participate in the firing of the FBI director who was leading the investigation into the Russian interference with the 2016 elections. Prior to Jim Comey's termination, were you contacted by the Donald Trump administration, anyone in that administration, Donald Trump himself or any of his political or campaign officials, about their quest to fire Jim Comey?
I am not able to and cannot reveal conversations with the President of the United States or his top advisors.
Let me ask you this question. With regards to the AT&T proposed acquisition of Time Warner, which owns CNN, it appears to be a vertical merger, much like the Comcast-NBC Universal merger that DOJ approved. But unlike its treatment of Comcast-NBC Universal, DOJ has suggested strongly that it will not approve the AT&T Time Warner merger unless Time Warner sells off CNN's parent company, Turner Broadcasting. It's well known that your boss, President Trump, has great disdain for CNN, which he calls fake news. And what I want to know is, has the White House or any individual in or on behalf of the Trump administration or the Trump political team or campaign, excluding staff from FCC or DOJ, has anybody contacted you, your office or your assigns regarding that AT&T Time Warner acquisition?
First, I would say that I don't accept and cannot accept the accuracy of that news report. We have a professional.
So your department has not told Time Warner that and AT&T that they must shed Turner Broadcasting?
Our work is professional. They do meet with the.
Is that a false report or is it a true report?
I just would tell you, I don't think it's. I'm able to accept as accurate news reports that have been come out on that.
Let me ask you this question. On October 18th, when testifying before the Senate Judiciary Committee, Senator Sass asked you if the department had taken adequate action to prevent election meddling in the future. You stated that there was no review underway of the cybersecurity vulnerabilities. Have you requested a review of what laws need to be updated in order to protect our elections from foreign influence?
We have discussed those matters, but no completion has been done.
Are you conducting a review at this time?
Yes. Our team is looking at that. The FBI has real skills in that area. And I think we're not anywhere near where I would like us to be yet.
Let me ask you
Mr.
this
Johnson.
question. What individual with your department is leading that inquiry?
We would be working with our voting rights section, our criminal section, our national security section, probably is the most knowledgeable in the hacking and area, as well as the expertise in the FBI.
Time of the gentleman has expired. The chair recognizes the gentleman from Texas, Mr. Smith, for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, first of all, I want to thank you for all your efforts to restore the rule of law. Nothing could be more important to our justice system, and nothing could be more important to protecting the lives of Americans and frankly, not just protecting the lives, but keeping all Americans safe. In particular, many of us appreciate your efforts to crack down on sanctuary cities that blatantly ignore federal immigration laws, to combat criminal gangs that prey on our communities, to return to robust prosecutions of drug cases, to protect children from dangerous child predators, and to safeguard religious liberties that are enshrined in our Constitution. I'd like to go back for a second to sanctuary cities. I have been waiting 20 years for a president and an administration that would enforce current immigration laws. So happens that I introduced a bill in 1996 with Senator Al Simpson that, among other things, outlawed sanctuary cities. So the law is there, and I want to thank you for being willing to enforce that law, which will protect many innocent Americans from harm and perhaps save their lives. More generally, I'd like to ask you if you feel that there are any immigration laws, and if so, which ones, that need to be better enforced.
There absolutely are, and maybe even some improved. I know you've worked on that, and the chairman has worked on that with some excellent legislation. I totally believe that the professional legislation I know the chairman has worked on and you've worked on would be tremendously helpful. We've got to deal with numbers. And so when you create a mechanism by which we had 5,000 people in 2005 who claimed a credible fear. Last year it was 95,000. This is creating hearings and backlogs that were never intended to be part of the system. Did not happen before. And so there's so many things out there that burden our law enforcement officers, make it more difficult, more expensive, more lengthy to complete these things. We've just got to make up our mind. We've got to make up our mind. Do we want a lawful system of immigration that serves the national interest? Or do we want open borders and we're not going to enforce it? Thank you for your leadership, Mr. Smith. I know you'll be leaving this body also, and I've enjoyed so much the honor of working with you.
Well, thank you, Mr. Attorney General. I'm not going to ask any questions, and I'm going to end with that, Mr. Chairman. I'll yield back. Thank you.
The chair thanks the gentleman. We're going to take a break, Attorney General Sessions, so the committee will stand in recess for 10 minutes.
Thank you. All right, roll time.
Oh, yeah, yeah.
I don't know what the trick is, but...
How are you, sir? It's tough.
Can I just send her time?
Didn't who say that? No, he said looks like is not an enough basis for a special counsel. Referring to Jordan saying looks like this, looks like right, exactly.
That's what I'm having her track down to see that exactly. It was sort of that's working.
I think maybe you just need to like continue to like law like all school walks and
I thought so. Yeah, go.
One guy was coming in and out, Garrett, but I mean, like, I don't think anybody has their names on these, you know what I mean? Garrett Hake from NBC is sitting here, but we might be able to fit all three of us there, to tell you the truth, you know what I mean? Hello? Yeah.
Okay, good.
Well, I think, listen, the headlines are, he insists that, he's not a liar, he didn't mislead anyone, he didn't recall that March 2016 hotel meeting until after he read the media reports. His recollection was that he shut the whole thing down. He studiously avoided commenting on the president's tweets, you know, to go after the Dems. He's committed to, if there's a special counsel, you know, without political interference. But there was a lot of frustration with Republicans. Jordan was very frustrated. He wouldn't answer questions about Comey, why there's no special counsel for him, and the funding of this dossier. And then there's a lot of frustration with Julia Jackson could not get a straight answer on, you know, what he could or could not remember about Russia. So, I mean, there's a lot of stuff. You know, there's this, I think, really important Roy Moore sound. He took a question from, I think it was Sheila Jackson, where he says, I have no reason to doubt these women and their stories.
Sheila Jackson,
So that's fine. I'm just saying, I just mentioned it. I don't need it. I'm just flagging it because we shouldn't get missed. Was my point. I think we can. Simpson. I don't know whether we've gotten him. He's not going into that session until 2 o'clock. You know, I mean, it may make sense if we're live at the top to move over to the House side and say, you know, the guy who commissioned that Trump dossier is still behind closed doors.
The committee will reconvene, and the chair recognizes the gentleman from Florida, Mr. Deutsch, for 5 minutes.
Thank you, Mr. Chairman. Attorney General Sessions, thanks for being here. General Sessions, who do you work for? Do you work for the American people or do you work for the President of the United States? Well, I'm a member of the executive branch, and I work for the American people. And it's with that in mind, your work on behalf of the American people, that I want to ask you some questions about facts and public media reports On February 14th, the president asked the FBI director about the Flynn investigation, and I quote, he said, "I hope you can see your way clear to letting this go, to letting Flynn go. He's a good guy. I hope you can let this go." Close quote. Then on May 9th, the president fired Comey. On May 11th, he went on television and announced that he fired Comey because of, and I quote again, "the Russia thing with Trump and Russia," close quote. General Sessions, do you think it would be reasonable for the members of this committee to conclude that the president, by first interfering in one investigation and then interfering in an investigation into himself, committed obstruction of justice? I don't believe that's a fair conclusion, and but it's a matter that I guess would be in the breast of the special counsel. The obstruction of justice being any, among other definitions, the most popular one in statute, any communication that endeavors to influence, obstruct, or impede the due administration of justice. That's exactly what the president did in both of those cases. And in spite of, moving on to the special counsel that you brought up, in spite of efforts, bipartisan efforts to protect the special counsel, Mr. Mueller, the Republican leadership in this committee have refused to take action to ensure that he's protected. Do you believe that the president has the legal authority to fire special counsel Mueller? I'm not able to express an opinion on that at this point. Can he fire members of the special counsel's team? I'm not able to answer that. General Sessions, do you believe that the president should have the authority to be able to block investigations into his own campaign? Investigations have to be conducted by the appropriate law enforcement officers without fear and favor, without politics or bias. Right, and without fear of being dismissed by the president in order to block that investigation, because again, that would certainly appear to represent obstruction of justice. And when you fail to acknowledge that, it is essentially a green light to the president to go ahead and do that. And now I wanted to talk about the special counsel's investigation. Thus far, there have been some indictments. There's a guilty plea. Can you tell me, in your opinion, does the president have the power to pardon George Papadopoulos? It would be premature for me to comment on that, I believe. Because the president has power to pardon. There's no doubt about that. Right. Does he have the power to pardon Paul Manafort and Rick Gates ahead of a trial and a conviction? I'm not able to comment on that. I haven't researched that question. I think it's settled, maybe settled law, but I'm not. What do you think the settled law is? I don't know. And does he have the power to pardon Michael Flynn, any other member of the Trump campaign? Let me ask you this. Does the president have the power to pardon his own family members? Could the president today pardon Donald Trump Jr. for, among other things, being in contact with WikiLeaks regarding these emails? Can he make those pardons today before there's anything further that comes from the special counsel's investigation? I would not be able to answer that at this moment with any authority. General Sessions, you started by telling us that you're the American people's lawyer. Now, you're not recused from giving us answers on these. You're not comfortable giving us answers on these. But here's the problem that we have. You said when you started your testimony today that there is nothing more important than advancing the rule of law. And when you answer the way you have, it suggests that the rule of law is crumbling at our feet. You took an oath to uphold the Constitution. We took an oath to uphold the Constitution. And while members of this committee and the majority may choose to abdicate their responsibility with regard to these very important matters, you cannot. And the interference, what you've told us today in just this exchange, what we should all be concerned about is another Saturday Night Massacre. If you can't tell us that the president shouldn't fire or can fire the special counsel and everyone who works for him. We should be worried if you're telling us that the president may be able to pardon in advance all of those who are being investigated. We should be worried about the pursuit of the rule of law.
General Sessions, again, we may in this committee.
The time of the gentleman has expired. The Attorney General can respond if he chooses
Well,
to do so.
just briefly, one of the things, if you respect the rule of law, is the Attorney General should not be giving legal opinions from the seat of his britches. So you need to be careful about that, and that's what I'm saying to you today.
I do appreciate that, General Sessions.
Expired.
These are not new issues that I would think require you to
Texas,
give these
Mr.
opinions
Poe.
from the rule of your
Thank you,
britches.
Mr. Chairman.
I
Mr.
yield
Sessions,
back.
I'm over here on this side. If pursuant to a warrant, there is a wiretap, conversation is seized under the Foreign Intelligence Surveillance Act, and one person is a foreign agent, the other person is an American citizen, is the release of the information regarding who the American citizen is and or the conversation of the American citizen a violation of federal law?
I believe it is.
And if somebody releases that information,
maybe factual distinctions.
I know,
I
I'm just
think
hypothetical.
it
Somebody releases the information of the name of that person and or the information contained by that person, that is a federal offense.
Unacceptable, and it could be a federal offense.
So has anybody been prosecuted under your regime for doing that, whether it's been in the White House or some other government agency where we hear about leaks of classified information? Are you prosecuting anybody for that?
For release of FISA-obtained information.
Release of the information of who the American is and or the conversation by the American. That's classified information. Is your department investigating anybody for that?
I cannot confirm or deny the existence
Or are
of
you
an
prosecuting
investigation.
anybody for that?
Nobody's under indictment, although we've got at least 4 indictments this year of leaks of classified information, and
I wanna
we
talk
will
about
continue to press those cases.
All right, good. We want to talk about the Foreign Intelligence Surveillance Act. Secret courts issuing secret warrants to get information on terrorists overseas. That's generally the purpose of the FISA law and FISA courts. Would you agree with that?
Well, that's not a perfect summary, but it's got
short
substance to it.
It's too short. We know we can't trust the NSA. James Clacker testified before this committee in 2013 that the NSA was not spying on Americans. Then all of a sudden, this guy named Snowden showed up, and we found out, whether I don't like Snowden at all, he ought to be prosecuted, I think. But anyway, we learned that the American public was being spied on by the NSA. Part of the Foreign Intelligence Surveillance Act gives the NSA authority to seize information like emails, text messages, communications by these bad guys, foreign agents or terrorists overseas, to collect their information to make sure that America is safe. During that process, as you know, they call it incidental information. Information on Americans, who they are, and what those conversations may be, is also seized. The NSA says that's incidental information. Now, it's my understanding the Justice Department is opposed to the USA Liberty Act, which would require that before government goes into that information on Americans, when they're not the target's these terrorists, goes into that information on Americans, that there has to be a warrant signed by a real judge that states probable cause before that information can be seized. Now, my understanding is the Justice Department, under your leadership, is opposed to that warrant requirement. Is that correct?
That is absolutely correct.
So you're a former judge.
Would-be judge.
Pardon?
A would-be judge.
Yeah, I want to be judge, yeah. I'm a former judge, too. You don't think probable cause and a warrant requirement is required to go into that information that is, first of all, the seizure is done by government without a warrant. So it's seized already. And before it can be then searched, you also don't require or believe that a warrant should be required by any court to go into that information.
Well,
I'm just asking the same question.
The courts have so held.
I'm not asking that question.
Well, I agree with the courts.
No, you agree
not
with
you,
the courts.
Congressman, on that. You get lawfully
Don't you
obtained
think that
records, documents,
reclaiming my time?
All right.
You agree with the courts on that, not me. But let me tell you something. It is the responsibility of Congress to set the privacy standard for Americans.
That is
my
correct.
personal opinion, and I think the Constitution supports it, that before government can go in and see something and then search it on an American citizen that's incidental to the search on the target, government should get a warrant for that conduct. That's spying on Americans. And we know that we can't trust the NSA to keep from doing that. Is that data ever destroyed on Americans? Or is it kept forever?
I believe it has definitely has a limited time span. I think it's 5 years.
So Americans shouldn't be concerned that information is being collected on them and searched, and we don't have any say-so about a
Has
warrant.
expired. The chair recognizes the gentleman
Thank
from
you.
Illinois, Mr. Gutierrez, for 5 minutes.
Mr. Chairman, before I begin, I think I have a solution that could allow the committee to move on to other important national matters like gun control and immigration. Your side clearly wants an investigation of Hillary Clinton, and our side has been begging for months to hold hearings and start an investigation of the Trump administration and campaign's improper ties to Mr. Putin and the Russian government. My solution would save the American taxpayers a lot of grief and a lot of money by eliminating the need for the investigations. I propose we simply go to the President and the former Secretary of State and ask them both to resign. I'll go to Hillary Clinton, you can go to Donald Trump, and we'll say them both to resign. Then we can move on as a nation from an election that just never seems to end. Now, I did Google organizations that Hillary Clinton leads, and it came out 0. So I'm not quite sure what you're going to get her to resign from, because she doesn't appear to be in charge of anything. Last time I checked, she got 3 million more votes than Donald Trump, but she lost the election. So I don't know, why don't we move on and really look at the nation? So, Attorney General, I'd like to ask you, you said earlier today it was a brilliant campaign, referring to the Donald Trump campaign. Is that true? You feel that?
It was a remarkable thing that overcame a lot of obstacles.
Brilliant campaign.
When
now,
people couldn't have...
In campaigns, candidates make promises during campaigns. You think candidates should fulfill the promises they make during campaigns?
People make a lot of promises, and
you think they should fulfill those promises. It was a brilliant campaign, remarkable campaign. And as a member of the cabinet of President Trump, do you feel an obligation to fulfill those campaign promises? I mean, when he asked you to come on, did you think you should fulfill the campaign promises?
I believe the Attorney General should enforce the law first
I
and
understand
foremost.
enforce the law, but he said you're helping him on the Muslim ban, on immigration issue. I mean, you think he should fulfill
President
those
makes
promises?
decisions, and if it's lawful, we defend it.
If it's lawful. If it's lawful. Okay, I like that if it's lawful. But you said it was a remarkable and brilliant campaign. He said, quote, during the second debate, "If I win, I'm going to instruct my Attorney General," that would be you, because he chose you, "to get a special prosecutor to look into your situation," referring to Hillary Clinton, "because there's never been so many lies, so much deception," end quote. And when Hillary Clinton responded, she said, "because you'd be in jail." Are you going to fulfill that campaign promise that he made during the second debate? Because he did say he'd put her in jail. He said he asked the Attorney General, you, to set a special prosecutor. That's what he said. It's a quote. I didn't make it up. What did he say? Are you going to keep that campaign promise?
I'll fulfill my responsibilities.
Are you going to keep the campaign promise? That's a yes or no. It's a promise that your boss, he hired you to fulfill. Are you going to fulfill?
We will comply with the law with regard to special prosecutor appointments.
Are you going to appoint one, as he promised during the campaign? He's reminded you a couple of times in a few of his tweets that that's what he wants you to do.
I'll fulfill my duty as Attorney General.
Okay. So the brilliant campaign, remarkable campaign, big smile on your face. You love the campaign, but you're not going to fulfill his campaign promises. I hope you don't in this particular case. So I'm kind of happy with your answer up to now. So, as Mr. Attorney General, I'm going to ask you another series of questions. And I'd like to go back to the beginning of the hearing and get you to answer the following question. Are you aware that you are under oath and that your answers must be the truth, the whole truth, and nothing but the truth, Mr. Attorney General?
I'm aware of that.
Okay, good. So I brought this little salt shaker here. And you'll forgive me if I just put a little bit of doubt into that answer. and just to remind myself that I might need this. And I ask unanimous consent that this article from Mother Jones Magazine be entered into the record with the headline, 3 times Jeff Sessions made false statements under oath to Congress. I ask this because I don't want to hear in a few days or in a few weeks that your answers, Mr. Attorney General, have changed based on newly uncovered evidence that what you told us before was in fact false, misleading, or something other than the truth, the whole truth, and nothing but the truth. I ask unanimous consent.
That objection be made a part of the record.
Thank you. Under oath, in the Senate, you said, as a surrogate, quote, a time or two for the Trump campaign, you did not have communication with Russians, but in March, it was revealed you did. Did you have campaign communications with the Russians? Because it appears you have had campaign communications with the Russians, Mr. Attorney General.
That is, I'd like to respond to that. I thought I had the paper right here. Surely I do. Here it is. Mr. Chairman, take a couple of minutes. I'd like to respond to that. Colleagues, I guess say former colleagues.
They left.
Senator Franken asked me this question. Okay, CNN has just published a story, and I'm telling you about a news story that's just been published. I'm not expecting you to know whether or not it's true, but CNN just published a story alleging that the intelligence community of the United States of America, the intelligence community provided documents to the president-elect last week that included information that, quote, Russian operatives claim to have compromising personal and financial information about Mr. Trump, close quote. These documents also allegedly say, quote, there was a continuing exchange of information during the campaign between Trump's surrogates and intermediaries for the Russian government, close quote. He goes on to say, now again, I'm telling you this is all coming out, so you know, but if it's true, it's obviously extremely serious, and if there is any evidence that anyone affiliated with the Trump campaign communicated with the Russian government in the course of this campaign, what will you do? I was taken aback by this. I'd never heard of this. This happened while I was testifying, I suppose. And I said, Senator Franken, I'm not aware of any of those activities. I have been called a surrogate a time or two in the campaign, and I did not have communications with the Russians, and I'm unable to comment on it.
And you're not going to correct that today?
My answer was responsive to his charge about a continuing...
But you want to correct it or clarify it today for us?
The time of the gentleman has expired. The Attorney General can answer the question, but then we're moving on.
So this is really important. I appreciate the opportunity to share it. So my focus was on responding to the concern that I, as a surrogate, was participating in a continuing series of meetings with intermediaries for the Russian government. And I certainly didn't mean I'd never met a Russian in the history of my life. So I didn't think it was responsive, and my response was, according to the way I heard the question, is honestly I could give it at the time. I hope you'll treat me fairly when you evaluate that.
The chair recognizes the gentleman from Pennsylvania, Mr. Marino, for 5 minutes.
Thank you, Chairman. Thank you, General, for being here. I appreciate it. I'm going to ask you some questions because I am the chairman of the Regulatory Reform and Antitrust Subcommittee on Judiciary. And antitrust is an issue that is now surfacing more so than it ever has in the past. And the Justice Department's role is very critical in antitrust issues to determine whether there is an antitrust violation. I understand that the Justice Department's position on the AT&T merger will require divestment of some assets. Behavioral conditions have been used in vertical mergers since they pose a lesser danger to competition and horizontal mergers. Is the structural condition in vertical mergers a policy for DOJ at this point?
Antitrust policy is important. I've never been an expert at it. It was one subcommittee of the judiciary I never chose to be a part of. But we have an experienced team in the Department of Justice. We do try to handle each case professionally. We have a good chief now of the Antitrust Division, and I'm not able to announce any new policies at this time, Congressman.
Will there be a discussion concerning vertical and horizontal mergers when it comes to the so-called term behavioral conditions, where two companies that are merging may have to divest? Could there be future discussion as to when this behavioral condition would be implemented?
Well, the vertical horizontal issue is something that has always been part of the discussion. I don't think it's dispositive of any final decision, but I'm really not able at this time to comment on anything that would be part of an ongoing matter.
Understand.
And I appreciate you giving me an opportunity to not attempt to answer that.
I'm going to switch to human trafficking now. When I was a U.S. attorney, we handled some very heartbreaking and very severe situations concerning human trafficking. And I know that you understand, like I understand, the challenges involved there. But what can you tell me what DOJ has done in upping the prosecutions and the investigations for anti-trafficking?
We believe strongly that we can do even more. It's been a priority for a number of years. I was recently in the Minnesota United States Attorney's Office. They had a major international case, and I was surprised how much money was involved, almost as much as drug dealers may make. We have a recent report of our people meeting with the child exploitation group. My Associate Attorney General, number 3, Rachel Brand, is very interested in this, and I've empowered her to be engaged in advancing our efforts in this regard, and she's enthusiastically responding to that.
If I may make a suggestion as well, several years ago, we in the Middle District of Pennsylvania prosecuted one of the biggest sex trafficking cases on the East Coast, obviously for the most part, involving women and very young girls. We had a good conviction. These people went away for 30 or 40 years. But one of the areas that we have to help more with the victims is the protection side of things. Of course, during investigation and during the trial, but subsequent to the convictions, that these women and children aren't forgotten, and there are protections there to keep them from anybody else attempting to do what's been done in the past. And I thank you so very much for your service to us, and I yield back.
Thank you. Thank you for your service.
The chair recognizes the gentlewoman from California, Ms. Bass, for 5 minutes.
Thank you. Thank you, Mr. Chair. Between 1956 and 1971, the FBI ran a counterintelligence program named COINTELPRO that was initiated by J. Edgar Hoover. COINTELPRO mainly targeted civil rights leaders such as Martin Luther King, and it's commonly understood that this was an abuse of its surveillance power in a manner to suppress a peaceful movement. So I would like to ask, Mr. Chair, unanimous consent to enter this report into the record, which is Black identity extremists likely motivated to target law enforcement officers. I believe earlier you said you were not familiar with the report. Is that correct?
Well, I haven't read it. I know some of the alleged targeting of officers by
okay, so I would
group.
like to know, and I'll ask you about that in a minute. So you are somewhat familiar with it. Who had the power in your department to order a report like this?
I'm not sure how that report got ordered. I don't believe I explicitly approved it or directed it.
Okay, so you haven't necessarily read the report, but you are familiar with the term black identity extremists?
Well, I think so, yes.
So could you tell me what that term means to you? Do you believe that there is a movement of African Americans that identify themselves as black identity extremists, and what does that movement do?
Well, I'd be interesting to see the conclusions of that report. But I'm aware that there are groups that do have an extraordinary commitment to their racial identity, and some have transformed themselves even into violent activists.
Are you aware of white organizations that do this as well? Given that white supremacy is well-documented, well-researched movements such as the neo-Nazis, the Ku Klux Klan, etc., are they white identity extremists?
I didn't follow that question, please, again.
Is there a term or a report on white identity extremists? You mentioned you were familiar with black people who identify with their racial identity.
Yes, but it's not coming to me at this moment.
Not coming to you?
It's
certainly a group such as the Ku Klux Klan.
Yes, and then the skinhead movements, but there's a racial identity white movements that have been identified for sure.
So has the FBI done a report on white identity extremists that are likely motivated to target law enforcement officers? Is there such
I'm not aware of that.
Okay. Are you aware of a group called the Sovereign Citizens?
I've heard that group, yes.
And I believe that the Sovereign Citizens is primarily a white organization that absolutely has targeted police officers and killed police officers. You're not aware of that?
I'm not aware of all their crimes, but I know they're a group that's known to have violent tendencies.
Could you name an African-American organization that have committed violent acts against police officers? Could you name one today? In this report, they name organizations from 30, 40 years ago, but can you name of one today that has targeted police officers in a violent manner?
I believe I could, but I would want to be to confirm that and submit it to you in writing. But I believe we had, within the last year or so, 4 police officers killed by a group that some have described as extremists.
So what has happened is that there have been a couple of incidents in which African Americans did kill police officers who were not associated with a black organization. And so one, for example, in Baton Rouge was associated with Sovereign Citizens, which is primarily a white group. So you should know that there's a lot of concern in the community, especially from organizations such as Black Lives Matter. By the way, would you consider Black Lives Matter a black identity extremist group?
I'm not able to comment on that. I have not so declared it.
So you should know that a lot of activists around the country are very concerned that we're getting ready to repeat a very sad chapter of our history, where people who are rightfully protesting what they consider to be an injustice in their community, which is their relationship with police officers, are now being targeted and labeled as extremists and are going through periods of surveillance and harassment. And so I would like to know, what is your department going to do to protect the rights of average citizens to protest if they have a concern about police officers?
This department will not unlawfully target people.
So if that's the case, then I would ask that you review this report, Black Identity Extremists Likely Motivated to Target Law Enforcement Officers, because I personally don't believe that any such organizations exist. The organizations that are referred to in this report are organizations from decades ago. And so I would like to know, what will you do to essentially roll back what is listed in this report? Because it's not accurate. Sir?
We will look at the report. I actually would be interested in reading it. But they usually do an excellent job, objective and fair, on those kind of reports.
Okay, well, just...
Time of the gentlewoman has expired. The chair recognizes the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Thank you, Mr. Chairman. Thank you, Mr. Attorney General. I want to cover a couple of areas, but I want to start with something that's very important to me. I think it's important to all people in this country of good conscience, irrespective of their political ideation, and that is the independence of the Department of Justice. And in my judgment, 2016 and 2017 have been challenging years for the department. of Justice. The decision to charge someone carries with it multiple layers of review. There's a grand jury, there's a petit jury, there's a trial judge, there are post-trial motions, there's appellate courts, there are courts of habeas corpus, and then there's the media, and then there's Congress. But the decision not to charge someone does not carry with it the same corresponding layers of review. But in some instances, it's every bit as important to understand why law enforcement did not do something and why prosecutors did not do something. I'm not interested in relitigating the FBI's decision not to charge Secretary Clinton. That decision's been made, it's been explained, and I'm not interested in relitigating it. I am, however, interested in reviewing 2016 and 2017 with respect to the Department of Justice. And Mr. Attorney General, there was a time when my colleagues on the other side of the aisle were interested in having some of these questions answered as well. It wasn't a year ago that some of my Democrat friends wanted Jim Comey investigated and prosecuted for a Hatch Act violation. That was 12 months ago. And it was absurd then, and it's absurd now. But what's not absurd is when my Democrat colleagues ask, why did you decide to publicize one investigation but not another? Why did you decide to appropriate a decision away from the Justice Department, which is very unusual for the head of the FBI to serve as both the investigator and the decision maker? Just like Republicans wanted to know, Mr. Comey, did you reach your conclusions before the end of the investigation? Did you make decisions whether to charge or not to charge before you interviewed all of the witnesses? These are questions that, to me, go to the core of whether or not the department can be respected, separate and aside from politics. I mean, I guess that certain departments are just inherently political, but the Department of Justice should not be. And so I tell you that up front, that Chairman Goodlatte and I are going to be looking into the decisions made in 2016 and 2017. And I think I can speak for him, and I know I can speak for myself. My motivation is a love for that department and a love for the concept of blind justice that doesn't care whether it's an even-numbered year or an odd-numbered year. And to the extent that there were decisions made, including the decision to write a public letter in October of last year and follow that up with another public letter in November, those are legitimate questions, and I hope that the department will cooperate both with respect to making witnesses available, but also with respect to documents so Congress can better understand the decisions that were made and not made and restore some modicum of trust that all people, whether they agreed with the decisions or not, at least understand why they were made. Now, Mr. Conyers asked you whether or not it was appropriate for the president
Could I respond just briefly to that? Yes, sir. You're familiar with the Inspector General,
I'm meeting with
and they make public of the FBI on the full and intense review by the Inspector General, and perhaps they can, under their rules of disclosure, perhaps you can inquire more about how that's ongoing. But I'm not able to give the details to you at this time. That's a serious matter. It's in my response to the chairman of yesterday.
Well, I didn't intend to ask you to respond to it because you're right. Mr. Horowitz is looking into it. In fact, I'm meeting with Mr. Horowitz this afternoon, not in that capacity, but in another. And you're right. At some point, he's going to let Congress know what he found, but that does not absolve us of our responsibility to also look into it. Mr. Conyers asked you whether or not it was appropriate for the president to weigh in an ongoing investigation. And, of course, the answer to that is no. It is not appropriate. It's not appropriate in 2017. It wasn't appropriate when President Obama did it in the IRS targeting scandal. It wasn't appropriate when President Obama did it in the ongoing investigation into Hillary Clinton's server. It is never appropriate for a president to tell a Department of Justice what outcome it should reach. I just wish my friends on the other side had the same outrage when President Obama did it as they do now. I mean, I guess that's what this will be my last question to you. You're nominated by a president. You're approved by a Senate, but yet you work for a virtue. You work for a blindfolded woman holding a set of scales, and that is what makes our culture different. How do you restore people's trust, Republicans and Democrats, confidence in a Department of Justice when it seems like different rules apply depending on who's in power?
The time of the gentleman has expired. The Attorney General will be permitted to answer.
Well, it's a good question and an important question. We intend to do our work according to the established principles of the Department of Justice. We will not be infected by politics or bias. We will make only decisions we believe are right and just, and we're not going to use the department to unlawfully advance a political agenda. We're going to enforce the laws of this country effectively as Congress has passed them, and I am determined that when the years go by, that people will say this Department of Justice did not crumble. It stayed firm and true to the great principles that I was taught in the 15 years I served in the Department of Justice, 2.5 as an assistant, 12 as United States Attorney, and looking up to the Attorney General is somehow so far removed from me that it was beyond recognition. But now I'm in that position. I think I understand the gravity of it. I think I understand the importance of responding to your question, and we'll do our best.
Thank you.
The chair recognizes the gentleman from Louisiana, Mr. Richmond, for 5 minutes.
Mr. General, I have the honor of serving as chair of the Congressional Black Caucus. You were not there, but I'm sure you are aware, and if you're not aware, I'm telling on myself, that I testified against your nomination. And I did so because I was afraid that we would go back to a time where discrimination was rampant and that diversity was not appreciated and that the right to vote for minorities and African Americans would be further, more obstacles would be set up. And I listened to your opening statement and I listened to your remarks since then, and you talked about voter ID. The VC case, which in Texas ruled that their Texas voter identification law had discriminatory portions against African Americans. The district court ruled that way. The appellate court affirmed that ruling, and then you withdrew from the case after 2 courts ruled that it was discriminatory. How does that mesh, and then argued on the side of Texas, how does that mesh with the right to make sure that African Americans had unfettered access to the voting polls?
Congressman, the way that happened was that Texas had passed a voter ID law that the courts did not approve but struck down. Election was coming up, I believe, and the court approved a voter ID procedure that they approved for that election. And the Texas legislature then repealed its previous law that had been found to be unconstitutional or improper and passed the one that the court had approved. So we felt that the voter ID law has been approved. A proper voter ID law is constitutional, and we believe that one is constitutional, and that's why the position was changed.
And also in judging Department of Justice, in terms of nominating judges to the bench, our information tells us that out of all the judges that have been nominated, I think 91% have been white males. Does that foster diversity?
I'm not aware of the numbers, but you should look for quality candidates, and I think diversity is a matter that has significance.
Well, the National Bar Association could recommend and has recommended a number of African American and other minority attorneys who are qualified. So let me just ask you, and if you don't know the answer to these, just let me know that you'll get me the information. But how many African Americans do you have on your senior staff?
I do not have a senior staff member at this time that's an African American.
Out of all,
I would note in Alabama, I participated in recommending an African American judge, and I've had judges before. And
we're talking about this administration, though. Of all of the U.S. attorneys that have been nominated or confirmed, how many have been African American?
One in Alabama that I've recommended that I knew.
And I believe
he's been confirmed.
I believe it's only that one. Out of all of the special agents in charge of FBI bureaus around the country, how many are African American?
I do not know.
Would you get that for me? And here's the gist of what I'm saying. For a lot of people who objectively look from the back, like I do and many people where I live, the question is whether we're going towards inclusion and diversity or whether we're going back. So I applaud the president for his approach to the opioid epidemic, which everyone in this room is concerned about. We're losing over 100 people a day. But your decision to reverse Eric Holder's Smart on Crime initiative goes back to the crack, tough on crime, and I think you specifically said that you want the U.S. attorneys to charge and pursue the most serious, readily provable offenses in sentences. But with opioids, we're treating it as a mental health crisis. And the question becomes from the outside looking in, is it because of who the opioid crisis is affecting as opposed to crack? Our answer to crack cocaine was mandatory minimum sentences. So the question is, how does an outside observer reconcile how we treated crack, and which led to mass incarceration, which now with the epidemic we're losing thousands and thousands of people a year, and we're treating it with hugs and kisses and treatment as opposed to tough on crime, lock them up. How do I reconcile that and not conclude that the only difference is race and income?
Well, I would say that the federal court focuses on serious offenders, not users. We talk about international drug cartels. We talk about distribution networks, serious gangs, MS-13. We focus aggressively on that. But the PSN, new reinvigorated crime problem, focuses more, and I've been convinced of this, on the leading criminals in a neighborhood. And the federal government will not seek mass incarceration so much as we will be focusing on identifying the people who really are the driving force, maybe sucking other young people into crime that would never have been brought in there if they hadn't had this leadership drive. It's worked in New York, it's worked in other agencies, and I think it will work here. And Congressman, I would note that the average federal sentence in the last 3 or 4 years has dropped 19%, and the federal prison population is down 14%, while we are beginning to see a spike in homicides, the likes of which we hadn't seen since the 1960s.
Time of the gentleman has expired. The chair recognizes the gentleman from Texas, Mr. Farenthold, for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, thank you for being here. Before I got to Congress, I was a computer consultant, so I'm a little, I sometimes dive into the nerdier end of things. The incursion into the DNC servers is back in the news recently. My question is, can you tell us if anyone at the DOJ, FBI, or any other federal law enforcement agency has been able to take a look and forensically examine that server to determine who hacked it, whether it was the Russians, an inside job, or somebody else?
You said the
DNC.
DNC. I'm not able to comment on that. It's an ongoing investigation. And
I appreciate that. We've also talked a little bit today about the FISA court and 702 and surveillance. And one of the things that I don't think has been completely answered is why does the DOJ think it's so problematic to require a warrant from the FISA court before or any court before accessing or disseminating the contents of communications that aren't related to foreign intelligence that deal with American citizens?
Well, the way, maybe I should explain this. When you have a warrant or you have a surveillance on a foreign individual that may be connected to terrorism or any foreign individual, you listen to who they talk to. And if they call an American and you have a terrorist on the phone in Syria, You want to know who that American is.
But
Frank.
the USA Liberty Act includes exceptions for emergencies and for individuals who are reasonably believed to be engaged in international terrorism or furthering their goals.
Well, I'm not sure I understand it.
There's an exception for dealing with emergencies and people who believe to be terrorists. It's the whole.
All right. Well, let me just say this. So if we get a lawful intercept from a federal judge of a mafia person in New York, he's not likely to be talking to many people not in the United States. And we're listening to the conversations of the people he talks to, and they're American citizens. And if they talk about a crime, you can use that evidence against them, and you don't have to have a separate warrant to access it. We're talking about in the 702 I hope you'll think through with me now. So you lawfully obtain this information. You could do it by hand in the old days, but now the computers do much of the work for us. So you know the names of the people that may be involved in this activity, and you can access those records just like you could access bank records that you got.
If it came up in any other way, you would have had to have gotten a warrant to get that wiretap.
Well, the problem with the warrant is, let's say this. Let's say you have information from an airport that somebody wants to learn to fly a plane but does not want to learn how to land the plane, as we saw one time.
And you go to the court and get a warrant in a matter of hours.
That does not give probable cause to tap that person's phone.
I've got a couple other questions.
Okay,
I appreciate your answer on that. I do want to talk. In the last Congress, we passed and enacted into law the Stop Advertising Victims of Exploitation Act, or the SAVE Act. This legislation makes it a criminal offense to advertise for commercial sex acts. Has the DOJ used this provision to prosecute online sex traffickers or websites they use, and if not, why not?
I'm not sure about that, Congressman. I'll have to maybe can get back to you on that.
I would appreciate that.
Thank you.
All right, I've got a couple more here. I want to hit it, but I'm going to kind of take a step back and look at the big picture. I'm a lawyer. I went to law school. I've always considered the Attorney General to be the people's attorney. And I feel like over the past few years, under previous Attorney Generals, that the Attorney General has been more the President's attorney rather than the people's attorney. Can you tell me what you are doing in office to restore the confidence in the American people, both in the office of the Attorney General and agencies like the FBI, which most people used to have a very high respect for, but I believe that level of respect and trust has dropped dramatically in recent times?
These are serious questions. I believe as you get to know the FBI Director, Chris Wray, the new director, you will find him to be a man of high intelligence, great integrity, great character, and great capability. Clearly one of the nation's great lawyers in private practice, but many years in the Department of Justice as a prosecutor working with FBI agents. That's one thing we've got. I can tell you I have great confidence in him. My deputy, 27 years of professional that I chose to be my primary deputy. My associate attorney general, likewise, is a woman of the highest character and academic excellence and experience in the department. We are setting a tone of professionalism every day in what we do. So I think that's something we need to do. There are some matters that do need to be completed. The Inspector General is doing investigations of some significance, as in my letter. I believe you received a copy involving the FBI and the allegations that are there. We intend to make sure that no agency of the government, not just the FBI, is not following the kind of disciplines and practices they should follow. So I guess I would say to you, watch what we do. We're not going to be driven by politics. We're going to try to do the right thing, and I believe that time will show that to be true.
I see my time has expired. Thank you, Mr. Chairman.
The chair recognizes the gentleman from New York, Mr. Jeffries, for 5 minutes.
Mr. Sessions, I have a copy of the transcript of your testimony before the Senate Judiciary Committee in October, you stated under oath, "I don't recall," in some form or fashion 29 times. Is that correct?
I have no idea.
I have a copy of the transcript of your testimony before the Senate Intelligence Committee in June. You stated under oath, "I don't recall," in some form or fashion approximately 36 times. Is that correct?
I don't know.
In your testimony today, you have stated, "I don't recall," at least 20 times. Is that fair to say?
I have no idea.
Now, on October 4th, 2016, during a TV interview with Lou Dobbs, you criticized Hillary Clinton for telling FBI investigators, "I can't remember," approximately 35 times. You also stated during that Lou Dobbs interview that the intentional failure to remember can constitute perjury. Mr. Attorney General, do you still believe that the intentional failure to remember can constitute a criminal act?
If it's an act to deceive, yes.
Okay. Now, you testified in January that you had no contact with Russian operatives during the Trump campaign. Earlier today, you testified that your story has, quote, "never changed." Is that correct? That was your testimony earlier today, that your story has never changed, correct?
I believe that's fair to say.
Okay.
We've added things that I did not recall at the time.
Right.
So my statement at the time was my best recollection of the circumstances, and as things are brought up.
Claiming my time, I understand.
All right.
Sir, you now acknowledge meeting with Ambassador Kislyak during the Republican National Convention, correct?
I remember I made a speech. He came up to me afterwards. I was standing in front of the speaker program and did chat with him.
Okay, thank you. And you
encounter, not a meeting. It was just an encounter at that time.
Okay, and you also met with the ambassador in September of 2016 in your office, as you've acknowledged, correct?
He asked for an appointment. I had two senior staffers, both full colonels in the United States Army, retired in the meeting with me.
You testified in June before the Senate Intelligence Committee that you had not heard even a whisper about possible Russian involvement in the Trump campaign. Yet we understand that you attended this March 31st meeting where George Papadopoulos talked about potential communications with Russian operatives. But also, according to your third quarter 2016 FEC filing, you hosted a Trump campaign dinner meeting on June 30th, 2016 at the Capitol Hill Club. Is that right?
That's correct.
And your Senate reelection campaign paid for that meeting. Is that right?
I think that may be so.
Okay. And Carter Page and George Papadopoulos both attended that June 30th meeting, correct?
That has been reported.
And at that meeting, Carter Page told you that he was going to Moscow in a few days. Is that right?
Yes.
Okay.
And
thank you.
He said it was a brief meeting as he was walking out the door. I don't recall that conversation, but I'm not able to dispute it.
Understood. Reclaiming my time, I've got limited time available.
That is not, does that establish some sort of improper contact?
I think you understand.
Russians?
I think you understand.
He's not Russian either. You know.
Understand, sir. I get to ask the questions. You provide the answers. In this capacity, you're no longer in the United States Senate. You voted in 1999 to remove Bill Clinton from office on charges of perjury, correct?
That is correct.
And connection.
Well, there were other charges. I voted
simple
for
question.
impeachment. Yes.
Yes, understand. To remove him, actually, impeachment's in the House. In connection with that vote to remove President Clinton from office, you gave this speech on the Senate floor on February 29th, 1999, and in it, you acknowledged that while serving as U.S. attorney, you once prosecuted a young police officer who lied in a deposition. And in that speech, you decided to prosecute that young police officer even though he corrected his testimony. Now, you've testified under oath before the Senate Judiciary Committee in January. You subsequently corrected that testimony in a March 6 written submission and have been forced repeatedly to come back to the Senate and now the House to clarify. When explaining your vote on the Senate floor to remove Bill Clinton from office, you stated that you refuse to hold a president accountable to a different standard than the young police officer who you prosecuted. Let me be clear. The Attorney General of the United States of America should not be held to a different standard than the young police officer whose life you ruined by prosecuting him for perjury. I yield back.
The gentleman may respond if he chooses to.
Mr. Jeffries, nobody, not you or anyone else should be prosecuted, not me, or accused of perjury for answering the question the way I did in this hearing. I've always tried to answer the questions fairly and accurately. But to ask, did you ever do something, do you ever meet with Russians and deal with the campaign? You're saying Mr. Carter Page, who left that meeting, according to the press reports, and I guess his deposition or interview has been reported as saying, I'm going to Russia. I made no response to him, didn't acknowledge it. And you're accusing me of lying about that? I say that's not fair, Mr. Jeffries. I would say that's not fair, colleagues. That's not on any indication that I in any way participated in anything wrong. And the same with Mr. Papadopoulos. He talked about, it's reported in the paper, that he said something about going to Russia and dealing with the Russians, and I pushed back and said you shouldn't do it. So I don't think it's right to accuse me of doing something wrong. I had no participation in any wrongdoing with regard to influencing this campaign improperly.
The chair recognizes the gentleman from Florida, Mr. DeSantis, for 5 minutes.
Well, thank you, Mr. Attorney General. Just not giving you any benefit of the doubt at all to do what these guys are doing to you. So I hear what you're saying, and you didn't do anything wrong there. I do want to talk to you about your recusal from the Russian case. You cited 28 CFR 445.2 saying you were involved with the campaign. That triggered recusal. However, that regulation only applies to criminal prosecutions or investigations. When you recused yourself under James Comey's admission, that was a counterintelligence investigation, not a criminal investigation. So why did you cite that regulation to recuse from a counterintelligence investigation when its only applicability is for a criminal investigation?
I'm not sure that was expressed to me when I was giving advice about it in those terms, number one. Number two, it could likely be interpreted as both. And so I felt...
Comey, after you recused, he testified March 20th. He said, I'm authorized to say there's a counterintelligence investigation. He was telling the president, you're not under investigation. So that's what he said. So I think that may have been misapplied, but I understand what you're saying.
I did follow the advice I was given.
I know you did. You've talked about you can't confirm or deny investigations. I think that's a good policy. Why was Comey allowed to confirm that investigation in March 20th, which invited all kinds of irresponsible speculation? You were recused. Somebody in the department authorized him to do that. Why did they break with the policy?
This was this March 20th you're talking about? I'm not, I don't recall how that exactly occurred, but I do agree with you, Congressman, that Mr. Comey talked more than he should. And he had no power, right, or justification in announcing the conclusion of a criminal investigation. He was the investigator, not the
I agree. I don't want to try to interrupt. I got limited time. I agree with you. Let me move on. Uranium One case. I know you've been asked about it. Can you say, forget about whether it's under investigation, in the past, did the FBI or DOJ inform either President Obama, Secretary Clinton, or any cabinet secretary that it had uncovered evidence that Rosatom's main U.S. executive, Vadim Mikirin, was engaged in bribery, kickbacks, and money laundering before the Obama administration approved the Uranium One sale in 2010?
Is that the Mickerin matter, the matter that was prosecuted in Maryland?
2014, but there was an informant in 2009, 2010. The FBI had evidence of bribery, kickbacks, and money laundering. Was that information conveyed to any of the relative people on the CFIUS board? Clinton, other cabinet secretaries, or was it given to the president?
The way I understand that matter is that the case in which Mr. Mickerin was convicted was not connected to the CFIUS problem that occurred 2 to 3 years before. When the case came to the United States Attorney's Office, Mr. Rosenstein's office in Maryland, CFIUS had already been approved by 2 years or more.
There was an FBI informant starting in 2009.
I have not talked with him, but Department of Justice, I understand, has approved him providing information to the Congress, and I understand it'll be set up in a few days, and you'll be able to hear from him direct.
I think you should too, because from everything I've been proffered, he has evidence of illegal conduct 2009 and 2010 before this deal was agreed to involving Uranium One. It was all connected, and so I think that that's something that we need to do. Let me move on. The leaking you mentioned, you can't confirm or deny the existence of the leaks. Michael Flynn, some of these other leaks used politically against the administration. So let me ask you this: since the president was elected, has anybody been held accountable criminally or administratively for leaking information against the administration with a political motive?
Well, I think the individual in Georgia had a motive that's been charged, but we have 27 ongoing investigations. Some of those involve leaks before President Trump took office and some after.
Final question, just yes or no.
Before that, there was only 3 per year, only 9. There's 3 times as many this year as in the entire 3 years before being investigated.
Final question, why can't you just tell us whether or not the FBI expended resources to give money to Christopher Steele? It's not about going into the investigation. We have oversight over your department. Were taxpayer dollars used to give to Christopher Steele, yes or no?
I'm not able to do that. I think for several reasons. It's an ongoing matter, and also it may well involve classified information.
Thank you, Mr. Attorney General.
The chair recognizes the gentleman from Rhode Island, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman. And I apologize in advance, Mr. Attorney General. I'm going to try to go through some questions quickly. Multiple trustworthy reports revealed last week that the Justice Department may require AT&T to sell CNN, among other assets, as a requirement for the approval of its proposed acquisition of Time Warner. Subsequently, more reports have surfaced that Rupert Murdoch, the chairman of 21st Century Fox and a confidant of President Trump, has twice contacted AT&T in an effort to buy CNN. This is, of course, very disturbing to those of us that are responsible for oversight of these issues. And my first question is, has any White House employee or official, including the president, contacted the Justice Department regarding the AT&T Time Warner transaction or any other transaction?
I'm not able to comment on conversations or communications the Department of Justice top people have with top people at the White House.
Well, Mr. Chairman, I'd ask that the witness be directed to answer the question. Either you're invoking the Fifth Amendment or you're invoking executive privilege. You just can't decline to answer because it's uncomfortable. So I'd ask, Mr. Chairman, that the witness be directed to answer my question.
The witness can answer the question in the fashion that he has determined.
Well, reserving my right, Mr. Chairman, and I'll move on. Mr. Sessions, are you not going to answer the question? Whether any White House officials have attempted to interfere or speak to the Justice Department about this transaction?
According to long-standing Department of Justice policy, the Department of Justice does not reveal privileged conversations or conversations between the White House.
I'm going to move on to a new area. The Foreign Agents Registration Act, you're familiar with it?
Right.
You think it's good policy?
I think it's a good law.
You enforce it, correct?
It has value, yes.
In addition to Paul Manafort and Michael Flynn, have any other Trump campaign advisors or senior administration officials lobbied for foreign governments without disclosing it under the Foreign Agent Registrations Act?
I'm not able to comment on that.
Why not?
Repeat the question. Perhaps I misunderstood it.
In addition to Paul Manafort and Michael Flynn, have any Trump campaign advisors or senior administration officials lobbied for foreign governments without disclosing it under the Foreign Agent Registration Act?
That would be a matter that should be directed to Mr. Mueller, I believe.
Moving to a new question. On October 6th, the Department of Justice, actually you, on the behalf of the Department of Justice, issued a 25-page memo to all federal agencies purporting to provide guidance on religious liberty protections under federal law. In the guidance, you indicate that an exemption or accommodation for religious organizations from anti-discrimination law might be required even where Congress has not expressly exempted religious organizations. You remember that, right?
Yes.
Okay. Would that mean, under your interpretation, that an employee of FEMA could refuse to provide disaster assistance to an unmarried couple who live together based on the employee's religious belief that men and women should not cohabitate before marriage?
I don't believe that it could be interpreted that way. It's just a policy document. We didn't try to write it.
I really like
well, you have to answer.
This is a yes or no. Would the guidance you provided permit a HUD-funded shelter to refuse to house an unmarried pregnant woman based on the grant recipient's belief that sex outside of marriage is a sin? Yes or no?
Every matter. First, I don't think so, number one, under the guidance, but also the guidance does not repeal established laws that are in place, and it was written, that guidance was to clarify the established principles
Thank you,
of
Mr.
religious
Sessions. I have very
freedom.
limited time. I appreciate your answer.
Well,
now returning to the Papadopoulos issue. In your October 18th testimony, you purport to have forgotten this conversation about by Mr. Papadopoulos about Russia that you put an end to. You said you weren't being dishonest, you weren't making a false statement, you simply forgot it. You remember that testimony?
Something like that,
okay.
Yes.
When did you remember the remarks of Mr. Papadopoulos? When did that memory come back to you?
I think it was when the press came up with it, or it was revealed in the press.
That was the first time you remembered it?
Just I would recall that my October statements was a broad question.
No, I understand. Mr.
And
Sessions, I have a limited time reclaiming my time.
Occurred
you were a senior, Mr. Sessions, you were a senior campaign official and a member of the National Security Team. Did you ever exchange any email, text message, or any other communication to or from Mr. Papadopoulos about Russia or any other subject?
Repeat the category, list of things?
Exchange any email, text message, or any communication to or from Mr. Papadopoulos about any subject?
I do not believe so. I'm confident. I did not.
Did anybody ever forward to you a communication from Mr. Papadopoulos?
I don't recall it.
Did anybody from the campaign ever communicate with you about Mr. Papadopoulos?
I can't say that there were no conversations about him before or after this event.
Were you told about
the push back at him.
Time of the gentleman has expired. The witness can answer the question.
Chair, I don't have a specific recollection, Mr. Chairman.
Mr. Chairman, I'd ask to make a unanimous consent request. I would ask unanimous consent to insert the following materials into the record. A letter from me and Ranking Member Conyers requesting a hearing on the President's interference with antitrust enforcement matters before the Justice Department. A letter from Senators Amy Klobuchar, Dianne Feinstein, and several others to the Justice Department urging it to oppose any attempt by the White House to interfere with antitrust laws, enforcement decisions, particularly for political reasons. A July article in the New York Times reporting that senior White House advisors have discussed using the AT&T-Time Warner merger as a potential point of leverage over CNN, and 9 letters from as far back as February of this year from various members of the Judiciary Committee seeking information on a wide range of subjects addressed to the Attorney General of the United States that have been ignored, that we have received no response from.
Without objection, the document made part of the record. The chair recognizes the gentleman from Texas, Mr. Ratcliffe, for 5 minutes.
Thank you, Mr. Chairman. Mr. Attorney General, good to see you. If FBI Director Chris Wray held a press conference tomorrow without your knowledge to announce a charging decision in a major federal investigation, would you consider that an inappropriate departure from longstanding Department of Justice and FBI policy?
Under the situation today, under the letter that Deputy Attorney General Rosenstein wrote with regard to Mr. Comey, I think it would be a terminatable offense. That's not discipline. We need to be disciplined in this department. We don't need to be leaking, and we don't need to have people taking actions outside their realm. Maybe sometimes people make an honest mistake, but that would be a very dramatic thing, which he would never do.
So I'll take that as an emphatic yes. Now, to your knowledge, are there currently federal prosecutors in your office that are predetermining cases prior to the interviewing of key witnesses to include the subjects or targets of those investigations?
I don't believe so.
Is it a practice in your Department of Justice to allow immunized witnesses to sit in the interviews of the subject or target of federal investigations?
That would not be a normal process for sure.
Mr. Attorney General, these are just a few of the irregularities or anomalies that have taken place in how the Department of Justice and the FBI have handled these investigations and prosecutions prior to 2016, and now apparently a departure from how you're handling them. It's also these irregularities that have shaken the faith and trust of people in our Department of Justice. Look, I'm of the opinion that for the last 8 years we have survived the worst presidency of my lifetime. My colleagues on the other side of the aisle have spent their time today trying to convince you that we have to survive a bad president right now. That's okay. For 240 years, our republic has withstood that. Elected officials come and go. But right now, where we are, and what our history won't tell us, is what happens to our republic if people lose all faith and trust in the Department of Justice and the FBI to fairly investigate and to prosecute violations of the rule of law. Now, at one point in time, you and I held the same position in the Department of Justice. I was U.S. Attorney, as were you. You've obviously been promoted. If public opinion polls tell us anything, the chair that I hold right now signals that I've been demoted. But my time as U.S. Attorney taught me something that you said in your opening, which is that the Department of Justice must always transcend politics to uphold the rule of law. I think more than anything else, what the American people want to hear from you today is that that is in fact the case. As Mr. Gowdy said in his line of questioning, Lady Justice is supposed to be holding a set of scales, wearing a blindfold. She's not supposed to have her finger on the scales. And I think that the American people have every reason to question whether or not that's where we are right now. So more than anything else, what I'm asking from you is to hear from you that you are prepared, that you are committed to go wherever the facts and evidence lead you, regardless of the political consequences for any political party or any person, to include Donald Trump or Hillary Clinton or yourself.
Yes, I am, and the Department of Justice is. You will soon have Director Wray, I believe, coming before your committee. I hope you'll ask him these questions, and I think you'll be impressed with his commitment in that regard. As United States attorneys, we were raised in that idea. I've never forgotten. I'm glad I had my 15 years in the Department of Justice before I came to Congress. You get your values shaped maybe at a younger age. But I think I understand the role I have, the responsibility we have to do justice. And I would say this, that in the long run, if I want the respect of this body, both sides of the aisle, I've got to follow the rules in the department. And it may frustrate you that I can't answer questions or confirm you or other members on this side. It may frustrate people on this side. But if I'm not prepared to do that, then I don't think I'll ever restore the Department of Justice. And that's what our goal would be, to hopefully it's not as bad as you say, but I think there's danger out there, and we want to fix it.
Mr. Attorney General, thank you for your continued service. I yield back.
The chair would advise members of the committee that there are about 8.5 minutes remaining in this vote. The gentleman from California has persuaded me that will permit him to proceed but other members are advised we will reconvene immediately following this vote series. And the gentleman from California, Mr. Swalwell, is recognized for 5 minutes.
Thank you, Mr. Chairman. Thank you for appearing, Mr. Attorney General, and please express my gratitude to the men and women who serve the Department of Justice. You stated in your opening statement that my story has never changed, but Mr. Attorney General, it has changed 3 times, and today we heard the 3rd edition when you told us that you do now recall Mr. Papadopoulos mentioning that he had contacts in Russia. And so I have a slide for you that I'd like to display. It's a January 10th, 2017 exchange with Senator Franken where he asks about campaign communications with Russia. And you stated, Senator Franken, I'm not aware of any of these activities. Mr. Attorney General, if you were asked that question today, recalling that you are now aware of what Mr. Papadopoulos said on March 31st, would you answer that question differently?
All I would say to you, Congressman, is if you fairly treat the exchange I had with Senator Franken, I think you can understand where when I answered the question, I felt like I was answering it properly.
But you would agree today it should be answered differently if it was asked in the same form today, considering your recollection that you just gave us?
I believe that when you're asking me today, explicitly, did you meet with any other Russians?
Today,
I am prepared to say I did. I met with the ambassador in my office with at least 2 of my staff, senior respected patriots, colonels retired in the Army,
and Mr. Attorney
nothing
General,
improper occurred at all.
Once and for all, can we answer the question?
I am once and for all answering the question, Congressman. I don't understand why you won't take my answer.
Well, we're on the 3rd edition, Mr. Attorney General. So during your time on the campaign, did any person on earth state that they were communicating with Russians, traveling to Russia, or asked the campaign to meet with Russians, to your recollection?
Was I asked that question?
No, I'm asking you today, to your knowledge, did any person on the campaign tell you they were going to Russia?
I'm prepared to answer the question, but I just will not answer it in a way that suggests that I in any way intentionally misled anyone when I answered the question.
What's the answer to the question, Mr. Attorney General?
The answer is I met with the ambassador in my office for less than an hour, I believe, and he came up to me after a speech at the convention when it was raised to me that this months later. Nobody said immediately it was an error. By press, I immediately revealed and acknowledged or told them the meetings I'd had.
With respect to Carter Page, he told you, as you just acknowledged, that he was going to Russia. He was also on the national security team, and this is the 2nd person within about 3 months now that is bringing up Russian contacts, and you did not tell him to not go to Russia. Is that correct?
No, I didn't tell him not to go to Russia.
And you didn't tell anyone else on the campaign that he had told you that?
I don't recall him saying that, but am I supposed to stop him from taking a trip?
Well, at that point, did you think that now that 2 people have talked about either going to Russia or having contacts with Russia, that the campaign where you were the chairman of the national security team might have a Russia problem?
Well, if I read what's been said about the Papadopoulos meeting, the one that was somewhat earlier than that, I did say you don't represent something to that. I pushed back at his trip and was concerned that he not go off somewhere pretending to represent the Trump campaign. He had no authority for that. This young man didn't have any ability and ought not to be going off representing the campaign.
Mr. Attorney General,
the next one is Carter Page, and he says, from what I see in his testimony, interviews, he said after the meeting was over, he goes out and
moving on, Mr. Attorney General.
He goes out and he says he's going to Russia. I made no response.
CIA Director Pompeo has called.
So what does that mean?
Well, the American people will judge that.
I don't think it means that I've done anything dishonest.
Mr. Attorney General, the CIA Director has judged that WikiLeaks is a hostile, non-state intelligence service. Do you agree?
I'm not able to disagree with that.
But candidate Trump, who you were working for...
He's more aware of its activities, perhaps, than I.
But candidate Trump said throughout the campaign, I love WikiLeaks. Do you love WikiLeaks, Mr. Attorney General?
I'm not a fan of WikiLeaks.
Do you think it was appropriate that Donald Trump Jr. communicated with WikiLeaks during the course of the campaign?
I'm not able to make a judgment about that.
Thank you again for time. The gentleman has expired. The committee will stand in recess until immediately after this vote.
Have a good day, man. I am. I'm going to go cover the luncheons outside.
Okay. We're stuck in this until the end.
Yeah. Get outside from here. That's a good idea. You like to look up? Gotta have one. No, I gotta cover the shit. I gotta All right.
Hey Claire, how are you? Yeah, they're on a 15-minute, I think 10 to 15-minute vote stuff. I got this call and chat with you guys about what you see as the highlights so far and see if we're all on the same page. Yeah.